In the judgment and order dated 18/7/2024 in cost title, name of respondent number 3 Rakesh Kumar Paswan has not been mentioned. Though in the status report, respondent number 3 Rakesh Paswan, name of Rakesh Paswan, it is for and order dated 1/5/2024.
No, what do you want? So it's a disposal matter.
Yes, ma'am.
You have to file CMP.
मेरा पिटीशन में गलती नहीं है.
तो CMP तो फाइल करना पड़ेगा ना, किसी की भी गलती है, हमसे भी गलती हो सकती है. You file a CMP, we will see what is to be done. क्या मैटर, क्या प्रॉब्लम क्या हो?
कुछ नहीं, कॉस्ट टाइटल में रेस्पोंड नंबर 3 का नाम छूटा है.
छूट गया है. फिर स्लिप लेके जरा दिखाइए.
ये जजमेंट है मेरे पास.
ठीक है.
Lordship, may I mention
फाइल मंगा लीजिए.
May I mention from the list or not?
We'll see what is the matter. We can't just adjourn matter.
For judgment item 1, MA 195 of 2020.
This appeal is dismissed. The other judgment will be pronounced in the same.
For final disclosure of this case, at 10:30, item 3, WPC 4768 of 2010.
Manoj sees the last order.
Yes, I've seen it. They have to respond.
They have to respond.
Lordship, I've been instructed that the matter may be remanded back
Remanded
to the GM. Lordship,
for what? For what
Lordship,
purpose?
since in this case, admittedly, there was a sanction load of 1 kilowatt, and based on the inspection, it was found that the appliance was of 6 kV. Now, as per Lordship, clause
You were
7.
to satisfy this court that the sanction load is 1 kW. Existing load was found to be 6 kW.
Yeah.
Then it has to be treated in domestic service only.
Lordship,
You can't
we can,
convert it into commercial.
we,
Yeah, and whatever be the consequences, treating this into domestic service.
Lordship, may I place your attention to clause 7.15 of the electricity supply code,
Okay.
that deals with reclassification of consumer category.
Mm.
and placing subclause 1 of that. If it is found that a consumer has been wrongly classified in a particular category, or the purpose of supply as mentioned in agreement has changed, or the consumption or power has
ये दे दीजिए जरा.
exceeded the limit of that category as per the Commission's order, the distribution licensee may consider reclassifying the consumer under appropriate category.
No, let me stand.
Now,
Please tell me one thing. Under the domestic category, is there any maximum limit of KW?
No.
If there is no maximum limit of KW and the category is domestic service, then under such circumstances, whatever be the consequences of having 6 KW, that has to be treated only under domestic category.
Lordship, but in the inspection report, since a note was there that the petitioner was running a workshop.
You
and-
see your counter affidavit. And you see, workshop means what? A person is cooking certain articles at home. It will be treated as a workshop.
Lordship, at that point in
And you say in your counter affidavit that numerous machines were recovered and found in the premises. Having one geyser at home, right? One mixie at home, one refrigerator at home, one TV at home, and 2 motor pumps and 1 exhaust fan. These are heavy machines.
heavy machine, Lordship, but at that point in time, it was not being used for at the point of
It
inspection.
does not partake the nature of a commercial use.
Lordship, if you can see, there are two motor pumps and it exceeds the 1 bhp, Lordship.
It
One
is
of
one
7.
thing to say that under the domestic category he has exceeded the load. It is another thing to say that merely because he has exceeded the load, it has to be treated in commercial.
Lordship, why it is to be treated, that is why I am coming to that. If we can see in the inspection report, there are two pump motors. One is of 750 watts and one is of 375 watts.
Yes.
It exceeds 1 bhp. And now, Your Lordship, may I turn your attention to page 36 of the writ application, Lordship.
Yes, that is. Yes.
Annexure 4,
This
which
is the date of inspection is when? 19/7/2010.
10, and this is of the 2010 tariff only. Now it says for domestic services, this schedule shall apply to private residential premises for domestic use for household electric appliances such as radios, fans, televisions, desert coolers, and including motor pumps for lifting water up to 1 bhp for domestic purposes. Now,
Let's let him read the entire thing. Let's
and other household electrical appliances not covered
under any other schedule.
schedule. Now, Lordship,
Show me
Even-
something that if this is 1 bhp,
it crosses 1 bhp
I do not know.
nominally, Lordship.
I just do not know how to convert it.
Lordship.
I don't have any idea how to convert bhp into HP and vice versa.
Lordship, I had
Therefore-
oral instruction, but I can, if your Lordship would allow, then I
No,
can
no, we
place
are
the
not.
calculations.
No.
Now,
You were asked to demonstrate that
No.
merely because a person exceeds a particular load, the category has to be treated as commercial.
no, general in
And you tell us, merely because a person is making certain items at home for the purposes of some kind of sale in his sweet shop, will it become a commercial category?
Lordship, if the consumer is using it for domestic purposes, then it will not be. But in the category itself, Lordship, page 38, domestic NDS, to whom it shall apply. If and in that workshop is defined, Lordship, and your Lordship would appreciate that.
Where is workshop defined?
Lordship, page 38 of the writ petition, non-domestic service category applicability. May I place it, Lordship? This schedule shall apply to the consumers using electrical energy for light, fan, and power loads for non-domestic purposes like shops, hospitals, nursing homes, clinics, dispensaries, restaurants, hotels, clubs, guest houses, marriage houses, public halls, showrooms, workshops, central AC units, offices, commercial establishments, cinemas, X-ray plants, schools and colleges, boarding, lodging, and there are a lot of lists. And since in the inspection report workshop it was categorically said that the petitioner was running. And Lordship, one more thing your Lordship would appreciate, his residential house was situated very nearby to his shop,
200 meters.
200 meters, Lordship. And only sweets were being made. It is not like he is using it for rest of the domestic purposes. So at that point in time, inspection was carried out and a provisional bill was given. Now, your Lordship, after that, since it was a workshop, it is not because of the enhanced load we have reclassified him in NDS. It is because he was using it for workshop is the reason that he has been reclassified in NDS.
What is the classification for commercial use?
NDS minutes.
Lordship,
It is NDS. Earlier it used to be minutes domestic, commercial, low tension, high tension special service. Now minutes commercial service has been given up. Now it has been treated as a non-domestic services.
This is in rural area or urban area?
It's Gumla falls under rural.
What is CS2 category? Where is that?
Which one? Millet?
CS2.
CS2.
Because category of service non-domestic 1 for rural area not covered by area indicated in CS2 category.
For
that is-
NDS2 category.
No, CS2 category. Category of service.
Millet, it is service category. If mileage would see non-domestic service 1 rural, for rural area not covered by area indicated for NDS2, and just below that is
Indicated for CS2.
It
I,
might be
it's page
typing
47. It's a
Page-
typing error.
page 47.
47.
Paragraph 2.
It is the same. It should have been NDS2. It is mentioned as CS. Commercial, let's earlier, commercial service and
Your
non-domestic,
Lordship
it's
can,
one and the same.
Turn to page 38, Lordship, same wordings are there. Only instead of CS, NDS is written.
Has the workshop been defined anywhere? Factories advocate. Factories advocate.
Same sir. Well, it's a factory has been defined. I have flagged it, well, but workshop has not yet not been defined as such.
Lordship, in my humble submission, factories and as per workshop as per factories that would be dependent upon the number of workers. Here it is not the case of number of.
That's it. Everything done at home may not come within the meaning of the workshop.
But Lordship, it is apparent that for what purposes the appliances are being used.
That's right.
That has to be taken into consideration.
What appliance was used for the purposes of manufacturing or whatever?
Lordship,
The
all those
sweets.
appliances, had it been
What
the
iron
case,
is used for that?
Lordship, mixie, pump, anything,
Mixie, everybody has at home.
Lordship, but if it is used for making anything related to sweets or your sweet shop continuously, then Lordship, I am trying to harp upon the fact that it is not based upon the unit consumption that a category has to be defined. A person having 1 kilowatt category can either opt for domestic use also and can also opt for NDS2 also. It is based upon the for what purposes you are using the same appliances.
What do you have to say, Mr. Murthy, for this argument that it was being used as a workshop, whatever?
Now let's their own counter affidavit. If I can just take mileage 2 for a moment, if mileage would come to page 3 of their counter affidavit. Now let's whatever arguments they are saying is contradictory to their counter affidavit. Page 3 of their counter, paragraph 10. May I just read it, Millet?
Yes.
After skipping, I'll read the entire paragraph 10. Before going into the facts of the case, it is essential to state that the history which gave rise to this case, respondent number 5 and 6 along with other officers visited the house of the petitioner after a complaint was lodged from the resident of the area. Upon inspection on such and such, in the presence of petitioner, it was found that petitioner is running a workshop for preparation of sweets behind the house for the selling through his shop located at Gumla in the name of such and such, and many heavy electrical instrument has been installed for the purpose. Now if I read these 4 lines with the inspection report, it does not corroborate.
You just read further. Thereafter.
Thereafter, the load inspection report was prepared and it was found that the petitioner was using 6 kilowatt load against the sanctioned load of 1 kilowatt DS. Subsequently, a load inspection was prepared and handed over to the petitioner, who has also signed the same. Now, if mileage would see the inspection report, there are maybe 8 or 9 numbers of instruments which has been mentioned. Do they want to say that all these articles which is installed was being used simultaneously? It doesn't happen, Mills. It doesn't happen like that. Mixer, grinder, geyser, water pump, all machineries are being used at a time, simultaneously. And that is what this Honorable Court Division Bench has been pleased to hold at page 39. If
Connected load.
Yes, Millet?
Connected load.
Connected load. So Millet, they cannot arm twist me just like that. Millet, the judgment of Sujata Picture Palace has not been disturbed till date. They have not taken it to appeal, Millet, before the Supreme Court. Connected load, Millet have read the judgment. And Millet, if they themselves are saying that behind my house,
Let us see that portion of the judgment.
yes, Millet, page, page 39, Millet.
The tariff and all, it does not define a workshop.
No, it doesn't. It doesn't.
It's page 39.
Page 39. May I place it, Millet? Consequent upon an inspection raid on the petitioner's premises cinema halls on 28/1/2000 by the officers of Respondent Electricity Board, the quantum of assessment was adjudicated by the order dated 7/6/2000 passed by the General Manager of the Respondent. That order was unsuccessfully challenged by the petitioner appellant before a learned single judge by means of a writ petition which was dismissed by the impugned order dated 7. We have heard legal counsel for the parties at length today. At previous hearing on 17 July, the following order was passed in this case. Prima facie, the General Manager who passed the reason order pursuant to the direction of the appellant has not recorded a clear finding as to whether all three projects are in one hall and both the projectors in the other cinema hall can be operated simultaneously. Similarly, he has not recorded any finding as to whether both the central air conditioning plants can in the normal course be operated simultaneously. There is also no finding whether for operating a central air conditioning plant, both the motors are necessary or only one motor runs at a time. However, before taking a decision whether to remand this matter to the General Manager or not, for considering whether all the equipments, all the projects and all the air conditioned plants with the both motors
You can
fall
come to
within
the findings straight away.
Its finding is the next page. Paragraph 2 and 4. Connected load has been defined under subclause 14A of clause 2 of the Financial and Account Code issued by the Bihar State Electricity Board, which reads as follows. Connected load means the sum total of the installed capacity of all the energies consuming devices on the consumer's premises which can be operated simultaneously, excluding spare or standby capacity in the form of extra units or larger ratings than necessary. The words can be operated simultaneously is the crucial phase. The learned counsel for the board has argued that if all the energy consuming devices can possibly be operated simultaneously, whether with or without any objective of purpose, they should be deemed to be included within the definition of connected load. We do not think any rational person would possibly subscribe to such unreasonable view. In our considered opinion, there can be no possible doubt that the phrase quoted above can only mean the situation.
Hold on. You were referring to the wattage of the pumps, right? It was at which page number?
Means that the inspection report minutes?
No, not that.
33.
Page number?
That is the inspection report.
No. You see, he has two pumps.
Yes.
Is he using
yes,
it simultaneously? Both the pumps?
Lordship, that is not apparent from the
There-
inspection.
No.
And Lordship, considering all we are not on the point of connected load. I am admitting to the fact that all these appliances were not being used.
Simultaneously.
Yes.
Okay.
I am
But
on the,
still you convert it into a non-domestic attack.
that is because whatever appliances are being used are being used for the workshop. I am trying to harp upon your Lordship may kindly consider this fact that I am trying to harp upon the fact that he is using it for a certain purpose. Had it been a case that he did not have a sweet shop running 200 meters away from this place, then we could have considered it for DS3 category or DS2 category in a domestic service only. But since it was apparent Lordship why it is being used, maybe he was only using mixer only. Let us assume for a minute that he was only using one appliance. But if that appliance is being used for a particular purpose which is defined in NDS category, then it has to be reclassified. It is not a case, Lordship, that if someone is using up to 2 kVA, then he is domestic. If he is, there is no slab as such.
If practically I speak, today there are so many homemakers who are carrying out preparation of different bakeries and they are selling it out. So in that event, they should also be treated as non-domestic. That is not the scheme of the act. The scheme is even if I am carrying it out at home, but I am selling it outside. So the commercial activity is being carried out outside. The sale of sweets are taking place outside. So the word commerce is at the place where I am selling it, not at the place where I am carrying out the production. And there is they have not said a single word that how many workers were there, which heavy machineries were being used. They have not said a single word. And they themselves in their counter affidavit is saying that I prepare it at home and sell it outside. In the counter affidavit they have said.
There is no reference to Factories Act under the Electricity Act.
No.
Are you sure?
I have tried to because since my lord had posed the question on Thursday, so I tried to do it, but I could not get any hint of it in the entire Electricity Act. Save and accept the categorization which is there in the tariff. There is no other connection.
Okay, the learned counsel appearing on behalf of the respondents has.
And if I can just one moment, the bill which they have given, it's a loads inspection bill which they say, there is no bifurcation, no details, no calculation. How do they arrive at a figure of 1,82,000? There is no justification they have given. That is all.
I will dictate it in the second half. Let me just do a little work. Maybe that you might have missed it. Because this has to be resolved.
Yes.
Workshop is not defined. In absence of any definition of workshop and how many persons were actually working over there, you cannot, any kind of domestic work being, you have little cake shops being run at home online, isn't it? You will convert it into a commercial activity. So therefore, there has to be some guideline on workshop. In absence of any guideline, we are not going to remand it back because that will not serve any purpose. In absence of any guideline as to what would constitute a workshop, whether any employee, it is not even mentioned that there is a employee working in the premises. Forget about one order number. Even that is not mentioned. A lady cooks at home, right, and supplies cake online. Will convert it into a commercial category.
Let's in
Yes.
Ranchi, there are at least 100 bakers,
Lordship,
100
the
home.
shop which was situated, the consumer name is the same, the residence,
Maybe, but in absence of any guideline.
yes, that is there.
So therefore, this could be a reason to provide a guideline by the regulatory authorities. If it is not defined, I'll just check it up and then I'll dictate the judgment. Right. There is one matter fixed at 250, thereafter this matter.
Much.
Workshop must have some employee, isn't
It
it?
has to have.
Lordship, for the purposes of electricity consumption, we do not take the number of employees.
That's you have the regulation, complete set.
That regulation is a complete set.
Whatever you have annexed, this
No,
is the
yes,
applicable regulation.
Yes, supply code regulation, it is there. Madam. And we'll have given the Factories Act also. But
Item 5, WPC 5781 of 2016, along with item 6 to 9.
Where is the petitioner?
They have an alternative remedy.
They have an alternative remedy.
Let
The,
them
the only issue which the petitioner may put before my lords is the validity of the marketing disciplinary guidelines.
have they challenged it?
They have challenged it. That is the only thing, my lords, which my lords can decide, and then my lords remand them for the alternate remedy. They have arbitration clause also, and in some matters they have the provision of departmental appeal. So they can.
Item 10, WPR 7084 of 2019.
Yes, petitioner. Where is the petitioner? It's the same story.
Same.
Where is he?
In fact, Lordship, the other writ petitions,
I think all the orders are uploaded by now.
yes, Lordship, so all of them can be
And
tagged also.
even one check has been encashed.
Yes, in fact, they have all lapsed also.
They have lapsed.
So there are 4 other writ petitions now, all
We
of
will
them.
not permit them to avoid like this. We call Mr. Mehta. We also come at 1 only. You call Mr. Mehta, otherwise we'll pass the same motion.
I'll call.
Because the matter appears to be absolutely covered. आप बोर्ड में सही नंबर बता दो मिस्टर मेहता को इन्फॉर्म करिए
Item 11, WPR 6682 of 2023.
You are representing who?
This one number 3. Union.
Mr. Mehta hasn't come to the court today. Mr. A.K. Mehta hasn't come to the court today. No, we are not going to adjourn it like this.
I'm not.
There is no prayer for adjournment. We will dismiss it or whatever.
Your lordships.
There is no prayer for adjournment. He has a team of juniors.
Nobody is here.
He has a team of juniors, so I was just wondering if I can.
Somebody must mention on this day.
We'll dismiss it. Otherwise, also it doesn't help us. Okay, pass over. किसी को बोलिए आपको टाइम दिया हुआ है इसमें?
जी
वो first 10 cases. What should you? Where is the constitution?
item 50 item 50
Just
Fixed
a moment.
case.
There is a fixed case. Please hold on. It has to be taken up within first 50 cases. 15,
First 10 cases.
First 10 cases.
50
Where is Mr. Shresh Gautam? Yes, you are for whom?
And for the respondent.
Where is Mr. Shresh Gautam, the petitioner?
What happened, he has not marked the list. At the list में लिखा हुआ we need top 10 cases.
Yes, sir.
अब नहीं है
So dismiss कर देते हैं. Dismiss कर देते हैं. There is nobody. His name is there in the list.
Yes, yes.
Where is
And
he?
the order sheet itself, ma'am, can you see the order, last order? Order dated 20/9/2024. उसमें भी लिखा हुआ put up this case on 30th/9/2024 within first 10 cases.
And Mr. Ashutosh Anand was to be served the copy of the writ petition, copy of the order, isn't it? I've never heard this matter earlier.
Sorry, ma'am.
I've never heard this matter earlier.
No. All the time this case was listed.
You are there for the petition.
Praying for a short pass over, Lordship.
The matter was to be taken within first 10 cases.
Lordship, Mr. Shresh Gautam is the arguing counsel. He's in civil court. So he'll be coming in.
And what will happen with the first 10 matter?
But you have confirmed with the court master also. He said that it will be coming as per the Serratum.
Who said so? Just a moment.
I just
He is a court master.
Like,
I just confirmed with him. He told me, so accordingly I
Is he
informed.
the court master?
I'm so sorry, Lordship.
So don't take the name of court master. My
Apologies.
court master is here from 10 o'clock in the morning.
Apologies.
You can't ask anybody.
Lordship, apologies, it was my mistake. The court was in session, so I asked him. He'll be here in a half an hour.
let it be at 2:50, ma'am, after it.
There was a joint compromise, talks of joint compromise.
In this
It was going on.
What happened?
No,
Last date, both parties were present,
Yes.
and accordingly there was some
Is
sort
there any likelihood of some
no,
compromise?
in this case, the earlier the petitioner ready to pay rupees 8 lakh
Yes.
in lieu of the wages.
Yes.
Now they have filed a petition in which he has restricted that the 8 lakh he will pay along with the gratuity and PF
gratuity
amount.
and
Gratuity and PF
Yeah.
will include in 8
Yeah,
lakhs.
includes in-
That's why not the
Back wages includes gratuity and PF also.
No.
On that part, my senior will be in better position to assist.
the case was filed for release of the salary.
And you are not being paid.
No, I have not been paid salary. Now I have already retired.
Come in the second half. We do not know at what time the case will be taken up. We will take up this case as per our own timetable.
Apologies, Lordship.
At 2:50.
Not at 2:15. We do not know whenever we'll get time. Let it be there. We do not know. We have fixed certain matters. This was to be taken up within first 10 cases and he is not here.
ये सुबह में आके हम कंफर्म भी कर
और
लेते
साथ में ये भी बोल रहे हैं कि कोर्ट मास्टर से पूछना.
नहीं नहीं, that was a big mistake on my end.
साहब बोले कि नहीं ये ऑर्डर्स के बाद आपका केस होगा.
मिस्टेक की कोई बात नहीं. अब आप आराम से 2:15 बजे से लेकर 4:30 बजे तक वेट कीजिए, तब आपका केस होगा.
हम भी पहुंचेंगे.
कोई बात नहीं. आप ये पैसा आपको लेना है कि एडजर्न करना है?
नहीं
वेट करें.
My request was this case was fixed for today.
अगर आइएगा तो अगर आप एब्सेंट रहिएगा तब हम एडजर्न कर देंगे.
नहीं हम रहेंगे.
Orders Item 12, WPC 1652 of 2018, along with Item 13.
Yes.
In this case, right, order number 16, the report has been called for from the deputy commissioner. I am the respondent number 4 and 5. The respondent number 3 was my predecessor in interest, who sold the property during the pendency of the petition before this court, and I have been made party in the subsequent case. Thereafter, I came to know about
What
this.
happened regarding the report? Report has come.
While in this case, there was rent fixation proceeding initiative, in which the rent has been fixed by the house controller by annexure 6.
I want to know where is the report?
Whether the report has been came or not, I don't remember. It is to be inquired.
He has filed an interlocutory application for restoration of possession.
Yes, madam. They, according to my reply, they have vacated of their own because there was a criminal proceeding in which the son of the opposite party, the petitioner, has been put behind the bar, and thereafter there was conviction for 4 years, and thereafter the appeal filed. When he enlarged on bail in the appeal, then so motu he decided to vacate the premises. And thereafter a suit has been filed under section 6 of the specific relief act, and one
That suit
petition.
is also pending. Are you there in this case?
State was directed to submit the report.
You have vacated it. What report is required?
We have not vacated. We have not vacated. That is the order that we kindly see.
You have filed an application for restoration of possession.
I have filed an application for the restoration of possession for the part of which I have been forced to vacate. That is my application. Your Ladyship may kindly see the order dated 27/8/24.
The matter relates to fixation of rent.
This 1654 WPC number 1654 52 1652 fixation of rent was done, after which I filed an appeal, after which wherein I lost, and thereafter I preferred a revision. While the revision was pending, an execution proceeding was
For
taken
the quantification, for the realization of
for
rent.
the realization of rent. In the execution proceedings, I have been directed to deposit 6 lakh rupees, and I have also been directed to vacate the premises. In the execution of the payment, I have been directed to vacate the premises, based on which I came to this honorable court for the against the order, Your Ladyship, which was stayed, and I was directed to deposit 2 lakh rupees, which I did then. Subsequent to this order,
So you want to say that there can, in execution proceeding there could not be any order of eviction.
eviction precisely. If they have to get me evicted, they have to file a different proceeding,
That's
because it was only for the amount of realization of rent, which I am ready to deposit, which I have already deposited. That 4 lakh that I was supposed to deposit pursuant to the order of 27/8.
On account of non-deposit of the quantified rent, there could be another proceeding for eviction.
Exactly.
But at the stage of execution, on account of non-payment of rent, they could not have asked you to evict.
Because there was a dispute, we were saying that we have been forced to vacate. they are saying that we have vacated on our own free will. That is why state was directed to inquire into the matter and submit a report. DC was specifically directed by order 27/8/24.
You have filed your petition, right?
Yes, sir.
You have filed your petition. And then what is it that you have mentioned in your petition? You have been partly evicted?
I
What
have
is
been-
it?
No, this eviction, that restoration, because I was given a shop of 18 into 53. 18 feet
Let
into
me
53.
just see your petition seeking restoration. This is 6527.
They have filed two petitions. Stay of construction, that is 8541 of 2024, and another is 6527 of 24.
Your
That is
ladyship,
for the
I will say
restoration.
It
854.
shows that you have been completely evicted from the.
Now that I have been completely evicted.
When? What is the date of eviction?
They,
This was filed on 25/6/20.
Yes.
What is the date of eviction?
no mention. They have sumomoto themselves.
We have
Just a moment, please. Your conduct is not
I'm sorry.
proper
I'm sorry.
because you have in the garb of that order.
No, my lord. Otherwise, they could have, why they have filed a petition on C5/2024 for restoration of possession?
An
And they
eviction
have filed
suit filed by the respondent number 3 is still pending, which is filed in the civil court. During the pendency of that eviction suit, they went to the rent controller and thereafter they are contesting here. Even during the pendency, they also sold the property.
You said that you were partly evicted, which is not correct.
I was partly evicted at first.
Where
My-
is that interlocutory application
Your
or partial
ladyship, your
eviction?
ladyship may kindly see eviction number IA/2, that is page number 18. This is the application I have given to the police authorities in which I have specifically
Page
stated.
number
Page number 18
of the
of the IA number 8541/24.
8541. What is it?
This is the application I gave to the authorities.
You read it from your petition. You
Yes.
will not read your annexures. Read it from the petition.
Yes. Paragraph number 7 I have mentioned that it is pertinent to mention here that during the pendency of this writ petition and continuance of the interim order, the intervening respondents have forcefully thrown the petitioner's family out of the premise against the order and has demolished the entire
Para number? Para number?
Paragraph number 7 at page number 5.
Who are these intervening respondents?
Intervening respondents are the respondents who have, these are the people who have been given the property. Now
So they are third party.
Third party.
So you
Subsequently,
have a
the
cause of
property-
action against the third party.
I have the cause of action against the third party, which is why they are the intervening respondents.
Therefore, when you have a cause of action against third party, you have filed a case, whatever you in this writ petition, when there is a dispute between landlord and tenant, if third party is throwing you out of the premises, can any status quo ante be passed against third party?
They are already party in this writ petition.
Maybe.
They have filed intervention application
Allowed?
which has been allowed.
Okay, when was it allowed?
It was allowed on order dated 20th/12/2023.
That was through INM?
IA number 7607 of 2003.
In the subsequent case, I have been noticed. Then I came to know about this case.
This is IA number 7607.
7607 or 23 was filed by the interveners. Which was allowed.
I just want to know the date of disposition. Give me the date of your disposition.
The Commissioner has submitted a report
Saying what?
that is here. And the result of it calculates that it is on second matter. Based on civil 13. It appears from para 4 that
There is a dispute as they whether they voluntarily vacated or
it is specifically stated in para 2 of the page 2.
there is no paragraph.
Para 5
Yes.
sub para 2.
Paragraph. Yes.
यह
Here
कि जर्जर स्थिति के कारण एक दुकानदार किराएदार प्रथम पक्ष के नए भवन में अपना व्यवसाय स्वेच्छा से स्थानांतरित कर माह अप्रैल 2024 के पूर्व ही चले गए हैं। यह कि पुराना दुकान क्षतिग्रस्त दुकान अपने आप ध्वस्त होकर गिर गया। यह कि हालिया पर उनके भवन निर्माण प्लान हेतु नगर निगम द्वारा स्वीकृत नक्शा के अनुसार वे बेसमेंट एवं ढलाई कार्य माह अप्रैल
you
2024
see
में
this dispute we will not be able to resolve this dispute. Now as on date, a new building is under construction.
They have forced me out. And
May I assist?
So if you want to get back,
If your lordships allow me to assist.
yes.
Yes. Lords, my submission is, lords, that Lord, there was a stay continuing. Lord, stay, we have deposited 2 lakhs rupees. Stay means, Lord, that they will not evict us. Lord, can they adopt a procedure for evicting us, thrown us out like this, Lord, because we are the small people and they wanted to construct a multi-storied building. So my submission is, Lords, and therefore, Lord, the Honorable Court on the last occasion has directed me to pay rupees 4 lakhs, the rest of the amount. So we look into the
You
matter.
see, so far as the impugned order is concerned,
My lords.
let's have a look at
Yes,
it.
I agree, Lord. If
Right.
you order, that order, Lords, by which there was a direction, Lords, to vacate.
Yes.
Lord, that was in excess of, Lord, the execution process.
So therefore,
I agree.
so that so far as that part is concerned,
Well, that
we
will-
will set it aside. Whatever be the consequences amongst the party, you will settle your scores accordingly.
Lord, see,
Because we are only
that
concerned
order-
with them. Please appreciate that. There is lot of dispute. There is an ex-owner. Now a new owner has come. Now he has thrown you out. You will have your remedies in damages. You will have your remedy in getting possession of the property. You may have a remedy in getting a place in the newly constructed building. But these things we cannot appreciate.
Lords, no, it is not a question of appreciation. It is a question that in this manner, if the High Court's direction
The
is
report
violated,
of the Deputy Commissioner says
Lords,
that you have evicted it.
that report they should find. At least I must know
No,
what is the
no,
report.
Therefore, you just have a look. दीजिए भाई report नहीं देते हो.
रिपोर्ट का कॉपी हम लोग को दे रखा है कि इतना
नहीं,
हम
देखिए
लोग
ऐसा है कि
Lords,
whatever be the report,
we had gone to SDO, we had gone to the police station. Lord, there are all photographs that in what manner we have been dragged out. That Lord, say lady.
you prosecute them. You prosecute
Lord,
them.
everything.
You have lodged an FIR.
Yes.
Let there be a prosecution.
Lord, then the question is that if suppose Lord, if a lordships will today set aside the order Lords passed in that execution procedure, Lord, that order has already been implemented now. They got it implemented in spite of the fact that the High Court has stated that they should not implement. Now the fact is that today if it is set aside, then Lord, today the fact remains that I have been not forcefully thrown out of that entire premises.
That's
For that, then file the petition before the court.
Now I'm not. This is my submission. Because my submission is only this, Lord.
You have filed a title suit. Who has filed a title suit?
That is should have been filed by them, Lord.
This one number 3. This one number 3.
By the purchaser.
No.
No. The
By the
erstwhile
erstwhile
owner. The
The
erstwhile owner.
erstwhile owner has filed a title suit.
Yes.
What is the date of sale?
Date of sale is-
What is the date of the impugned order?
Date of the appeal order, Lord, in this present case.
21st December 2019. It is
No,
apparent
8/3/2019.
21st December 2019.
The impugned order, you want to see the impugned order?
I'm viewing the
That is
Is
8/3/2018. 8/3/2018. When was the interim order passed?
Interim order passed on minutes. It was passed on
9/4/18.
9/4/2018. Right?
yes.
Thereafter, another order passed by the Deputy Commissioner in appeal.
Just a moment. This order dated 9/4/2018 was not complied with, isn't it? And on 14/6/2018, it was submitted that the interim order, the amount of rupees 2 lakhs was not paid, right?
Yes.
Yes. So that order of payment of 2 lakhs and then stay of the impugned order, that conditional order was not complied. When was it complied?
It was the order dated 27 July 2018.
27 July 2018.
Yes, order number 5.
Okay. All right. Then the mediation, etc. failed. What is the date of sale deed? 11/10/2000
11/10/2019.
is the sale deed.
Respondent please hold 4 and 5.
Respondent number 3 sold to 4 and 5. You see, we will scrutinize the order which is impugned in the first instance. Ultimately, the executing court did not execute the directions. By virtue of the orders passed by the executing court, you have not been executed. Now, a third party has taken law in his hand and has evicted. So, you will have appropriate remedy against third party. But so far as this writ petition is concerned, it will be confined to the impugned order, nothing more. You can have n number of remedies. But how this court will grant you relief against third party? There is no such order. The status quo with regard to the property will be maintained. There is no such order. A person can sell the property with tenant. There is no legal bar.
No.
There is no legal bar.
No, absolutely
Right?
not.
The person has sold the property with tenant
Yes.
without disturbing you in any manner. Right? And that third party takes the law in his hand and evicts you. You have a remedy on that, but not here.
For that remedy, we have ultimately the last order. Otherwise, we would not have deposited the because that was in the writ petition. They have not filed with the petitioner, asking them to pay the entire amount.
So therefore, when were you thrown out of the property?
Yes, Lords. I have thrown out the statement which I have given. Paragraph kitna hai? Paragraph
And
number-
what was the quantification of the arrears of property, arrears of rent?
Arrears of rent, at the relevant time 6 lakhs.
8.5 lakh. 6 lakh was remaining, 2 lakh was subsequently deposited. As on date, 6.5 lakh rupees is what is due to be received to respondent.
That is
number
as
three,
on date.
out of which 4 lakh has been deposited by them on the last date relation, but we could not withdraw it because there was no clarity whether or not they have deposited. We have now come to the information that they have deposited it, so we may be permitted to withdraw that amount in nature. And then only 2.5 lakh rupees is what remains.
Where is the order which was under execution?
That's the order.
The order which was under execution.
House
Annexure 2. That is Annexure 1, page 17. The relevant portion is
It was made effective from 2013. Page number
Page 17 minutes.
17. 10,000 rent made effective from March 2013.
Because this has not attended finality, not for the reason that we have challenged the order passed in the revision applications.
The appellate court had directed payment of rupees 4,90,000.
That is not, that can only be decided according to my humble submission. When your lordship decide the revision applications along with the others, fixing rate of 10,000 is justified. If it is justified, then the matter is different.
The quantum of rent is also under challenge.
Yes, please. That is the revision, lords. Against that we filed appeal. After appeal, lords, that order of the rent controller, lords, has been affirmed. Thereafter, we preferred revision. And my only ground of challenge, lords, that it was not decided by the SDO, lords, who is the authority under the Rent Control Act. The issue was decided by the report of the circle officer. That report was neither provided to me. Those reports say something else. So rather, it is the issue to be adjudicated by authority, not by the authority who is not authorized under the Act. So a report is called for, and based on that report, how an order can be passed, unless that report is being adjudicated.
Okay, we will decide the case on merit. You argue your case. You argue your case. That the authority did not have the jurisdiction. Kindly demonstrate. Like Rent Control Act. Jharkhand building.
I am leaving this first case. Second case is coming. That is there are two cases. First case, 1652 is I have challenged the execution. That order in the execution case, eviction is not just.
Okay.
So to that extent.
Fair enough. Okay, fine. Let's dispose of this first.
Yes, it is only to that extent.
Okay. We'll
Now,
dispose
my
of
submissions may be recorded.
Yes, yes.
My first submission is that in this particular case there was a stay. I have already argued there was a stay.
Stay. You have given the date of stay.
Yes, stay.
Stay was practically from 9/4/28.
9/4/2018.
Yes.
So and this stay is being continued thereafter. They have initially part of the building they have rather demolished, and the petitioner had to leave that part of the building, and subsequently.
When was it demolished?
Yes. Just paragraph number 10 final eviction. Paragraph 10 minutes of my IA applications, IA number 854.
IA number?
IA number 854. That the reporter
854.
854.
8541. Okay. This has been filed recently.
Yes.
There is another IA for this is for stay of construction.
Yes, this is for stay of.
There is one IA for restoration of possession.
Yes.
This is 6527.
6527.
6527 of 24 possession.
Minutes.
What is the date of disposition?
Date of minutes?
This has been filed on 25 6/24. What is the date of disposition
Date of disposition.
in this interlocutory application?
We have mentioned in the reply. Did not disposition, that is in the month of April, they have vacated and shifted to their own building. And thereafter they filed in the month of May, 3rd of May 2024 for under section 6
Sir,
of the.
please don't be simultaneous. Yes, what is the date of disposition?
Date of disposition letter IN number 85854.
See, you are filing a petition for restoration of possession. I want to see what is the date of
You
disposition.
see, unfortunately, it was not given here.
Okay.
Yes.
Then-
That is, what is fact, Lord? I
No,
can
no, we
only say
want-
the fact. Lord, something which is not there, I cannot say.
Sit. You have filed one FIR also?
Yes.
Where is that FIR?
If
Because you say that you have filed an FIR.
yes, please. That FIR is page 18 of my IN number 8541. That is 18th of June 2024.
What is the status of this FIR?
That the state has to say. Your
This is FIR against whom?
Units 4 and 5.
Who are the interveners?
Yes. Because let's say even in a suit proceeding, let's say if suppose if during the pendency of the suit, if the land is being sold or the property, it is not that the plaintiff is to file a fresh suit. Lords. They are to be impleaded. So my submission in this case, Lord, here they have been impleaded as a party. My submission is only this. Once, Lord, they have been impleaded, either the Honorable Court should not have been allowed to implead them as a party at the relevant time and would have directed me to file a to pursue the Lord's entire remedy afresh. But Lord, that was kept pending. This was allowed, it was allowed a long back. It was kept pending. In the meantime, Lords, now therefore my submission is Lords, not this that if the Honorable Court's order has to be respected, then Lords, if it's to be respected, then petitioner should not have been thrown out one fine morning from the premises if the stay is being continued. This is one Lords. Now my respondent, my friend says that she has on her own has left the premises. So that means according to him the possession is being continued, but I left it. So that means that is in her possession. How can they demolish it and they can start making construction over it? So it is, your Lordship is, Lords, I do not differ that we cannot initiate another proceeding, Lords. But here, what if there is no respect of the High Court's order, and they have flagrantly, Lords, therefore, Lord, the Honorable Court has directed me to you deposit the rest of the amount, and accordingly a report was called for that we will look into. And the further construction was stopped. So therefore, my submission is, Lords, at least they should not have allowed, and the Lordship under Article 226 has ample powers. Even status quo ante can be passed by Lords. It is not a case in most of the cases where to do the justice, it was done, it was passed. This is my submission, Lords. And Lords, secondly, Lords, that last order, we have deposited the money of 4 lakhs, Lord. So, Lords, I have not filed the affidavit, but if the Lordship will permit me, I can also file the affidavit. Lords, my affidavit is ready. Or my statement can be recorded. Lords.
You see, 10,000 per month was fixed. From
2013, Lords.
sorry?
2013.
Any month mentioned?
March was the
March 2013. This amount, whatever you have paid by virtue of the orders of this court, can certainly not extend beyond the date you have been evicted. Either suo motu evicted or forcefully evicted, but this execution is taken, this particular order of payment of rent will freeze on the day you have been evicted from property. There cannot be any dispute on that. Right? So, the exact date of eviction I am not able to.
In their FIR that they have filed, they have written that today I have been evicted at 9:30 a.m. If the FIR can be
Yes,
seen.
the FIR is there.
What is the date?
18th June.
18/6/2024.
So 18/6/2024, you stand evicted. So at best, the rent can be paid only till this period.
I do not understand one thing. If your lordship is adjudicating the payment of rent,
No, because I am very clear on this.
no, it's
That I will adjudicate the impugned order.
just let it be. So
I will
therefore, by
only adjudicate the impugned order.
therefore, by
But by virtue of certain orders of this court,
yes.
payment has been made. So I have to take that also to a logical end.
Then, Milords, in that case, the eviction, in spite of a stay, has to be also taken to a logical conclusion.
No, there is no, you see, there is an order of a stay of execution order. That order by which you have been directed to be
But it's
evicted.
correct. That I am asking.
So therefore-
I'm submitting.
So therefore,
And the impugned order, Milords, there was a direction that
and you have neither been evicted by the landlord, original landlord, nor you have been evicted by the process of law. You have been evicted by third party. The day on which the intervention was allowed, there was no interim order that the third party will also not evict you. There is no interim order further extended.
so Milords,
So the order on which the interim, on the day on which the interim order was nowhere in picture.
Milords, then in that case, the subsequent order which was passed, in which the interim order has been allowed to continue.
Which order?
Yes, Milords. Last order.
After 20,
Milords, the last order which was passed by which I was relaxed.
yes, that was prior to allowing the intervention.
No, Milords. Reset.
Another order.
Reset order.
27/8/2024 order.
Yes,
27/8/20.
Milords.
Yes.
That is, Milords, 27/8, Milords.
27/84, an order of status quo was
Yes.
passed. And you stood evicted on 18/6/20.
Milords.
Where do you stand?
Milords, no, Milords. My submission is this. Milords, if there is a stay, Milords, stay, Milords, nobody will come. Nobody. Not only the party will not come. Even the person who is the party will not come and demolish it. It is not governed, Milords. Stay, it does not
The
govern.
status quo order
No, Milords.
require the property till further order status quo as existing today shall be maintained by all the parties.
Milords,
8/2024.
27.
8/2024.
Milord, that is after eviction. After
eviction.
I am not on this, Milord. I am in the first order.
In the first order, the
Stay
private
if, Milords. My submission is, Milords, for a moment. My submission is that the stay of the, Milords, it should be stayed. So this stay is not, Milords, against the person who are the parties. Other persons also cannot come and disturb it.
You see, there
So,
is an
Milords, if
order.
they have done it during the operation of the stay, then they are also liable for a
You
contempt.
see, it is not an order in rem.
Milords,
Whenever
then-
there is
then-
an order of stay of execution,
Milords,
right? You are protected by the process of the court, by the process of the executing court.
Milords,
You are also protected by the conduct of the
Milords,
party
it is-
before the executing court.
it is the
But
order
if a
here.
third person comes,
Milords, my submission is here. It is the order in rem. It is my submission is, Milords, one stay for demolition has been passed. Nobody, Milords, X and Y, Z will come and demolish it. This is my submission. Lords.
That's, I've taken note of
Your
this.
Lordship, I have one submission. In the IA that they have filed, if I may draw your attention to the affidavit has been filed by one Chetra Kumari, who purportedly is the daughter of the petitioner, and she has never been substituted. So, what is her authority to file this
Yes,
affidavit?
and we have stated, Lords, that is because
Whether
the
a
mother
power
is
of
seriously
attorney
ill.
has been given,
Yeah,
or
yes.
any power has been given, that document is also not on record here. Just by being a daughter, do you have the authority to file the affidavit when you have not shown itself? The IA number 85418.
Lords, what is the report of the Deputy Commissioner Lordship has seen?
You just place it, you have got a copy.
No, I have got a copy. This is the submission. The Deputy Commissioner is also not sure that the shop has been vacated.
Yes. You may know.
Lord, there was a direction to, if the Deputy Commissioner says that in what manner the shops has been vacated, and I have all the photographs, the police authorities are standing there, when I was thrown out from the shop.
You have lodged an FIR. That
Lord, I
FIR
have-
will be taken to
No,
her.
Lord, I am not on the scene. What manner the High Court's direction is being taken care of by the authorities? I am only,
You see-
my submission is limited only to that
You see
extent.
para number 2.
Paragraph
5.2 यह जर्जर स्थिति के कारण उक्त दुकान के किराएदार प्रथम पक्ष उनके नए भवन में अपना व्यवसाय स्वेच्छा से स्थानांतरित कर माह अप्रैल 2024 के पूर्व ही चले गए। ये भी तो रिपोर्ट है।
Lord, ये क्या है क्या? Let us see कि क्या है ना? ये पक्ष है, ये सबमिशन है।
काउंटर सबमिशंस ऑफ बोथ।
What by महाराजा मिष्ठान भंडार नाम से दुकान अवस्थित थी, जो उन्होंने सुमन सामंता से मासिक किराए पर प्राप्त की थी। या कि सुमन सामंता द्वारा अनुमंडल दंडाधिकारी गिरिडीह के न्यायालय में एविक्शन सूट 6/17 दायर की गई थी। इसमें प्रथम पक्ष को मकान मालिक सुमन सामंता को बकाया किराए की राशि 6 लाख रुपए का भुगतान करते हुए वादगत मकान को खाली करने हेतु आदेश पारित किया गया। यह कि इस आदेश के विरुद्ध उनके द्वारा उपायुक्त गिरिडीह के न्यायालय में अपील तथा आयुक्त उत्तरी छोटानागपुर प्रमंडल हजारीबाग के न्यायालय में रिवीजन वाद दायर किया गया। वह दोनों न्यायालय द्वारा अनुमंडल दंडाधिकारी गिरिडीह के न्यायालय द्वारा पारित आदेश को यथावत रखा गया, जिनके विरुद्ध उनके द्वारा माननीय उच्च न्यायालय झारखंड रांची में रिट याचिका दायर की गई। चौथा विमर्श यह कि इसी बीच सुमन सामंता द्वारा वादगत भूमि सहित संलग्न शेष भूमि भीमलाल स्वर्णकार पिता स्वर्गीय स्वयंसो साकिर मधवाडी बेगाबाट गिरिडीह को निबंधित केवाला से दिनांक 21/12/19 को बिक्री कर दी गई। यह कि भीमलाल स्वर्णकार जो भीम ज्वेलर्स के एक मालिक है और उन्हें अन्य मालिक द्वारा लूटपाट करते हुए एवं वादगत भूमि में गड्ढा कर महाराजा मिष्ठान भंडार दुकान को ध्वस्त कर दिया गया, जिसके समर्थन में उन्होंने कुछ फोटोग्राफ, वीडियोग्राफी एवं पेन ड्राइव एवं दोनों पक्षों द्वारा किए गए एफआईआर की प्रतियां उपलब्ध कराई गई है, जो अलग सीरीज 1 और 2 है। अब आगे
दोनों पक्ष ने FIR किया है।
दोनों पक्ष
हमने नहीं किया।
Yes, somebody, maybe third party has done it. You have done it.
नौ द्वितीय पक्ष की ओर से विकास स्वर्णकार को उनके भाई की उपस्थिति में उनके द्वारा अपना पक्ष निम्नवत रखा।
That's
अब हो गया, अब क्या रखा गया उसके बाद हम इसको पढ़ रहे हैं।
हम पढ़ेंगे।
Now let's come to the conclusion. चूंकि Lords, if I may be allowed to read Lords the last paragraph, चूंकि वादगत स्थल पर कोई भी स्वतंत्र गवाह गवाही देने से इनकार कर दिए जाने मामला कई वर्ष पुराने हो जाने के कारण यह जानकारी प्राप्त करना कठिन हो गया है कि प्रथम पक्ष द्वारा दुकान स्वतः खाली करा दिया गया या द्वितीय पक्ष द्वारा उनसे बलपूर्वक खाली कराया गया। यह सत्य है कि दुकान खाली हो चुका है और वहां द्वितीय पक्ष के निर्माण कार्य किया जा रहा है, जो उनके लिखित वक्तव्य में वर्णित है। So if the finding is not that who has done it, ये लोग बोलते हैं FIR नहीं लॉस किया ना, ये FIR what they say they have not lost FIR। हाँ, तारीख क्या है देखिए, 18 जून। वो मत बोले कि नहीं किया।
दोनों जने FIR कर दी।
Because वहाँ पर there was she was alone. The lady was alone because nobody is there. There are all the photographs. There was CD. It captured the entire picture. That in what manner she was thrown away from there. And moreover, this eviction proceeding is pending. The stay is being continued. In spite of that, if such a and she has gone to SDO. She has gone to DC. She has lost an FIR. Nobody is there to take action. So, in this manner, if somebody is being evicted,
Okay, WPC number 1652 of 2018 for the learned counsel for the parties. अपना appearance देंगे please. This petition has been filed challenging the order dated 8/3/2018 passed by learned Subdivisional Officer Giridih in execution case number 6 of 2017, wherein a direction has been passed to deposit the arrears of rent and to hand over the vacant possession of the shop to the respondent number 3. The learned counsel for the petitioner, while assailing the impugned order, has submitted that the order under execution was that the order passed in case number 1 of 2012, whereby an application under section 5 of Jharkhand Lease, Rent and Eviction Control Act 2005 by respondent number 3 was allowed for fixation of fair rent, and therefore the order of the executing court directing the petitioner to evict the premises was wholly without jurisdiction. The learned counsel has also submitted that an eviction suit filed by the respondent number 3, being eviction suit number 1 of 2004, was still pending, and the executing court, while executing the order of fair rent, had directed for eviction of the premises. The learned counsel further submits that by order dated 9/4/2018, the operation of the impugned order dated 8/3/2017 was stayed, subject to the condition that the petitioner shall pay rupees 2 lakhs to the respondent number 3 in 2 monthly installment. For some reason, the said order was not, the direction for payment of rupees 2 lakhs was not complied, which was brought to the notice of this court on 14/6/2018. However, the same was duly complied by the order dated 27, as is apparent from order dated 27/7/2018. He submits that on that date, the interim order dated on 27/7/2018, the interim order dated 9/4/2018 was directed to continue. The learned counsel submits that there was an interim order passed in favor of the petitioner upon deposit of rupees 2 lakhs, and therefore the petitioner could not have been evicted from the premises. He submits that the interim order has to be treated as order in rem for all practical purposes, and therefore neither the petitioner neither the respondent number 3 nor any other person could have evicted the petitioner from the premises. He has submitted that one IA number 6527 of 2024 has been filed seeking restoration of possession, and along with the said interlocutory application, one FIR has also been annexed indicating that the petitioner has been forcefully evicted from the property.
That FIR is in 8541 IA.
Achha, 854. एक सेकंड लिखिएगा. One IA number 6527 of 2024 has been filed seeking restoration of possession of the property, and another IA has been filed being 8541 of 2024, wherein a prayer has been made for stopping construction over the property. He submits that in the subsequent interlocutory application, a copy of the FIR has been annexed, alleging that the petitioner has been evicted by the interveners, who are the subsequent purchaser of the property, from the respondent number 3. He submits that the intervention application was also allowed by this court, and therefore the interim order passed by this court is binding on the intervener, and the intervener could not have evicted the petitioner from the property. The learned counsel has also drawn the attention of this court to the order dated 6/11/23, whereby the intervention application was allowed. 2012-2023
the IA for intervention.
2012-2023, wherein the interlocutory application for intervention was allowed. He has also referred to the order dated 27/8/2024, wherein interim order was passed to maintain status quo as it existed on 27/8/2024, and by the said order, the petitioner was directed to deposit ₹4 lakhs before the rent controller GD in the execution case. You have deposited this amount?
Yes, please.
The learned counsel submits that the amount of ₹4 lakhs has already been deposited before the executing court. The learned counsel submits that considering the totality of facts and circumstances, the respondent number 4 and 5, who are the subsequent purchaser of the property, have tried to overreach the orders of this court and have dispossessed the petitioner, and consequently the application for restoration of possession to the petitioner be allowed. That's it. The learned counsel
Just
appeared.
one more submission. That was by the order dated 27th of August 2024. It was while directing me to deposit ₹4 lakhs. The status quo was granted with a direction, that the Deputy Commissioner Gility is acted to make an inquiry and to submit it. That because Deputy Commissioner has submitted a report. So that's if Lordship wants to take into cognizance of that report. Which the finding of the Deputy Commissioner is that it is not uncertain, it is not
ascertainable.
Yes.
The learned counsel has also submitted that by the order dated 27/8/2024, the Deputy Commissioner Gididi was directed to make an inquiry to the effect as to whether the petitioner has been forcefully evicted from the premises or not, and to submit a report to this court. And a report has been submitted by the learned counsel for the state, a copy of which has been provided to the counsel for the petitioner, and he submits that as per the report, the Deputy Commissioner could not ascertain the date on which the petitioner has been evicted. He has also submitted that the report also indicates that on 18/6/2024 itself, there was a FIR lodged by the
FIR lodged by
respondent number 3 also?
3, no, 5 and 6. Intervenor.
By respondent number 5 and 6.
4
and 5 in connection with the same incident for which the petitioner had lodged the FIR on 18/6/2024. And thus there are case and counter case between the parties.
In this report, they have stated that it is verified that the construction is going
And
last time, and in the interim order, the construction has been stopped. Just only
in
this.
the report, it has been recorded that the construction was
लास्ट 5 मिनट्स द्वितीय पक्ष का निर्माण कार्य किया जा रहा है, यह सत्य है।
he has further submitted that the report also revealed that the shop premises has been evicted and construction is going.
Yes,
The learned counsel appearing on behalf of the state has submitted that the report of the deputy commissioner reveals that there are case and counter case between the parties. There is also eviction suit के बारे में भी है इसमें.
इसमें डीसी का रिपोर्ट में मिनट्स
न्यायालय में संधारित the learned counsel has submitted that the report revealed that there are case and counter case going on between the parties. A reference has also been made to the eviction suit number 6 of 2017. And the deputy commissioner has not been able to give a certain date on which the petitioner has been evicted. It also reveals that it was the stand of the correspondent that petitioner had suo moto evicted the premises. Stand तो था ही उनका. The learned counsel appearing on behalf of
one line. They have filed the suit for restoration of possession under section 6 of the specific regulated before the court.
what is that? Where is that mentioned?
I have mentioned in my para 12 of the reply to IA 8541.
आप तो प्राइवेट रेस्पोंडेंट है ना, आपकी बात अभी शुरू ही कहाँ थी, ठीक है, अभी स्टेट की बात है. You are for respondent number 3 or 4 and 5?
4 and
4 and
I represent respondent.
he minutes he is the interview.
The learned counsel appearing on behalf of the respondent number 3 has referred to his reply. Dated?
Respondent number 3 or
No, respondent number 4 and 5. आपका reply कहाँ है?
My reply filed on 19/8/2024.
19/8/24.
To the IA number 854.
19/8/24 to IA number 8541 of 2024 and has submitted that a suit for recovery of possession. What is the number?
111 of 2024.
A suit for recovery of possession has been filed, being original suit number 111 of 2024 by the petitioner
Yes.
in the court of Civil Judge Junior Division Munsif, Giridih under section 6 of the Specific Relief Act.
Date also may be indicated.
Yes, possession on 3/5/2024.
Yes, on 3/5.
Because 3/5 के बाद हुआ है, ये 3/5 है और वहाँ जो eviction हुआ है वो जून में हुआ है, complete eviction.
तो आप रिकवरी ऑफ पोजेशन
Part
3/5 में कैसे पाएंगे?
पार्ट में थोड़ा सा पीछे का जो तोड़े थे उसके लिए एंड फाइनल जो हुआ है वो जून में हुआ है.
And one FIR was also lodged on 18/6/2024. To this, the learned counsel for the petitioner has submitted that the original suit number 111 of 2024 was filed in connection with part eviction of the petitioner
But
from the.
it is for the entire one. I am having the copy of the claims.
अपने तो इसका कुछ भी रिकॉर्ड पे तो नहीं लाए कुछ भी इसका.
मैं रिकॉर्ड
I am having the copy of total 954
file it minutes.
schedule
I don't have any
954
problem.
square feet, 18 feet by
नहीं जो चीज
53 feet.
नहीं है रिकॉर्ड पे उसके बारे में हम नहीं बोलेंगे पार्ट इविक्शन. So, वो last sentence. The learned counsel appearing on behalf of respondent number 3 has submitted that the respondent number 3 is entitled for the rent for the period during which the petitioner has remained in possession of the property. The amount of rupees 4 lakhs has already been deposited before the executing court, and the respondent number 3 be permitted to, and the executing court should be directed to hand over the amount to the respondent number 3. The learned counsel has also submitted that there has been no violation of any interim order by this court so far as the respondent number 3 is concerned. She has also submitted that there is no legal bar in transferring the property even if it is under the possession of a tenant. She has submitted that the property was transferred by way of registered deed as back as on 11/10/2019 in favor of respondent number 4. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that an order for fixation of fair rent was passed by the subdivision officer in case number 1 of 2012 HR under section 5 of the Jharkhand Lease, Rent and Eviction Control Act 2005, wherein the rent was fixed at the rate of ₹10,000, made effective from March 2013. The matter was taken up in appeal, which was numbered as House Rent Appeal number 3 of 2013, and the appeal was dismissed.
Yes, please.
19/1/2017.
And the appeal was dismissed on 19/1/2017. The matter was taken up in execution, which was numbered as execution case number 6 of 2017. In the said case, an order dated 8/3/2018 was passed, wherein the petitioner was directed to deposit an amount of ₹6 lakhs, being reduced from March 2013 to February 2018, and a further direction was issued to evict the tenanted premises, which was a shop. The cause of action to file this case arose on account of the fact by alleging that the executing court had gone beyond the orders passed and had no jurisdiction to direct eviction of the property. After hearing the learned counsel for the parties and considering the facts and circumstances in connection with the order of eviction, this court is of the considered view that in a proceeding for fixation of rent and realization of rent, the executing court had no jurisdiction to direct the petitioner to evict. And consequently, the order dated 8/3/2018 directing the petitioner to evict calls for interference, and the order dated 8/3/2018 to the extent it directs the petitioner to evict the premises is hereby set aside. So far as the other portion of the order is concerned, the same does not call for any interference. Now it is to be considered as to the subsequent developments which had taken place during the pendency of this case. It appears that on 9/4/2018, the interim order was passed in favor of the petitioner, whereby the operation of the improved order dated 8/3/2018 passed in the execution case was stayed subject to the condition that the petitioner shall pay rupees 2 lakhs to the respondent number 3 in 2 installments. The said or direction of payment of rupees 2 lakhs was complied, though belatedly, as is apparent from the order dated 27/7/2018, and on that day, the interim order dated 9/4/2018 was directed to continue. This court is of the considered view that the order dated 9/4/2018 and also the order of its continuation passed on 27/7/2018 cannot be said to be an order in rem as argued by the learned counsel for the petitioner. The order of stay was binding on the executing court and the respondent number 3, who was party at the relevant point of time. It further appears that the respondent number 3 had sold the property by a registered sale deed to respondent number 4 and 5 by its sale deed dated 11/10/2019. There was no interim order passed by this court with regard to maintaining status quo with respect to the property, and accordingly no argument as such has been advanced by the counsel for the parties with regard to the legality and validity of the sale deed dated 11/10/2019, which has been executed by respondent number 3 in favor of respondent number 4 and 5. It further appears that the respondent number 4 and 5 had filed an application for intervention before this court, and the intervention application was ultimately allowed by order dated 2012-2013.
2023.
By order dated 2012-2023. Upon perusal of the said order, this court finds that no order with respect to the no interim order as such was passed on 2012-2023 with respect to the intervener, respondent number 4 and 5. The FIR, which has been annexed by the intervener in the interlocutory application, reveals that the grievance of the petitioner was qua the respondent number 4 and 5 alleging their eviction on 18/6/2024. Forcible eviction on 18/6/2024. It appears that the respondent number 4 and 5 has also filed another FIR in connection with the same incident. The present status of the criminal cases filed by both the parties has not been brought on record. It further appears that on 27/8/2024, when the case was taken up, the Deputy Commissioner was directed to file a report as to whether the petitioner has been forcefully evicted from the premises or not. And on that day, an interim order was passed that till further order, status quo as existing today shall be maintained by all the parties. And further, there was a direction upon the petitioner to deposit ₹4 lakhs before the learned executing court, which the learned counsel for the petitioner has submitted that the order has been complied. From the perusal of the order dated 27/8/2024, it appears that there was a specific order to maintain status quo as on that day, and the perusal of the FIR revealed that the petitioner had filed FIR revealing that the petitioner was evicted on 18/6/2024. Apparently, the records of this case goes to show that on 27/8/2024, when the interim order to maintain status quo for the property was passed, the petitioner was already evicted from the property. further appears that one petition for restoration of possession has been filed by the petitioner before the learned sub-judge, which has been on 3/5/2024, bearing original suit number 111 of 2024 under section 6 of the Specific Relief Act 1963. However, it is not clear as to why a petition was filed on 3/5/2024, although the petitioner has alleged that the petitioner has been evicted on 18/6/2024. The plaint of the suit has also not been brought on record, and no rejoinder to the counter affidavit filed by respondent number 4 and 5 on 19/8/2024 has been filed by the petitioner. Considering the totality of facts and circumstances, this court is of the considered view that although the direction to evict the petitioner, as has been ordered by the order dated 8/8/2018, has been held to be wholly without jurisdiction and has been set aside, but still the petitioner cannot be put in possession in this writ proceedings in view of the fact that the petitioner has admittedly not been dispossessed by the process of court or by any further order passed by the subdivisional officer after 18/3/2018, nor it is alleged by the petitioner that the petitioner has been evicted by respondent number 3 forcefully. In such circumstances, this court also finds that case and counter case with respect to the eviction of the property, eviction of the petitioner from the property on 18/6/2024 has been a criminal case has been filed by both the petitioner and the respondent number 4 and 5 against each other. Accordingly, the interlocutory application seeking restoration of possession, which has been filed on through IA number 6527 of 2024 on 25/6/2024 is hereby dismissed. So far as the payment which has been made by the petitioner is concerned, the amount of rupees 2 lakhs, 4 lakhs which was paid earlier.
2 lakhs was paid earlier.
So far as the amount which has been paid earlier amounting to rupees 2 lakhs, there is no question of refund of the said amount to the petitioner, as the same is adjustable against the arrears of rent as determined. The impugn order revealed that on the date of passing of the impugn order, there was total arrears of 6 lakhs. So far as the subsequent order, so far as the subsequent payment of 4 lakhs is concerned, the same upon being added to rupees 2 lakhs already paid would total to rupees 6 lakhs, which was shown as arrears in the impugned order dated 8/3/2018, in connection with which there is no dispute raised by the petitioner. Accordingly, the amount
No
of
dispute I am raising, notes, because the my application is pending, yet to be decided whether that fixation of rent is correct or not.
However, at this stage, the learned counsel for the petitioner has submitted that the petition as to whether the fixation of rent was correct or not. That is, there is a challenge to the order passed in case number 1 of 2012 by the subdivisional officer, dated 9/3/2012.
No, in the revision application, sorry. Order challenge in
अच्छा छोड़ दीजिए उसको छानना पड़ेगा. So far as
Substitution.
deposit of rupees 4 lakhs is concerned, it is for the executing court to pass appropriate orders in accordance with. छोड़ दीजिए इतना नहीं करना. हाँ बताइए दूसरा केस.
next case तो जो कर रहा हूँ. I'm not
It is only
prepared
for
for it.
quantum of amount,
It is on quantum.
yes, fixed by the, and it become
It has been confirmed by the commissioner.
This
For
is
which the
House
next
Rent
case is
Control
taken.
Revision 33.
That is an order not passed by the commissioner in revision proceedings.
concurrent funding by, from the review of
Just
the
a moment.
commissioners on the
Just a
quantum of
moment.
rent.
So infectious cases हो गया. Because इसको हमारा by request is just see I'm not prepared in this second case. Little bit tomorrow.
So far as
one, but tomorrow is not a problem. I don't think.
Not at all. No problem.
Tomorrow will call is.
WPC number 585 of 2019. The learned counsel for the petitioner submits that this matter will be posted tomorrow, as he has to get ready with the briefs. Post this case tomorrow. It will come tomorrow with regard to fixation.
I'm not the party in the second case. I was only a party in the first case.
You are not a party in the second case.
I'm not a party in the second. I do not represent anyone in that case.
No, I am not. Respondent number 5 is there, 6 is there, 7 is there.
I do not represent anyone.
What is the name of, what is your name?
Suman Samanta
I
is
do
there,
not
respondent
have
number
a
5.
file of respondent number
Who is
second
the,
file.
whom are you representing?
I represent
What is the
respondent
name of
number
your client?
Suman Samanta in the first case, not in
Suman
the second case.
Samanta.
Respondent number 5.
Samantha has been inflated as party respondent number 5.
They were never noticed.
She must have been.
Yes, yes. Yes, they've been noticed.
You have not entered appearance.
Not entered appearance, so I do not even have to file in the second case. Neither our name reflects in that list.
Well, 100 friend is appearing on behalf of 637.
इसी में हमको पार्टी बनाया गया बाद में. They have filed the petition. Petitioner filed the petition to implead me as a party. And therefore, respondent number 5 have already been noticed. May have not been. Yeah.
No wakalatnama has been filed. No, there is no delivery of notice also. You file. Be fair to the court. You seek instructions, then tomorrow this matter will not be.
As by
And just a moment. You see, the quantum of the very exercise of fixation of rent is under challenge. So therefore, that 2 lakhs rupees, that will also be taken care of by the executive. I will not say that you will retain that. If this order goes, entire 6 lakhs has to be refunded, isn't it? So we will modify that order accordingly. 2 lakhs ka bhi, it will subject to the decision by the executive. You have already received it. 4 lakhs is lying over there, so that will not be fair. And so far as this case is concerned, you entered your appearance. You are in touch with the client. You have entered appearance.
Yes.
Copy me
I have filed one IE also.
You saw the copy. So it will come post vacation. इसका record मंगाना पड़ेगा. Is it required? Record would be required. We have to see how the exercise has been done. Record of the this original court, the appellate court, as well as the revision.
Revision, the case is pending in the revision.
No.
Therefore, they say 585.
When
Against the revisional order, the 585.
From the review of the commissioners, all likely to
All the 3 records, right?
Yes.
It is going to be a contested case. We need to see that. दूसरे केस में देखिए. WPC number 585 of 2019. Counsel for the parties are present. Counsel for the MS, your name, Prerna Jhunjhunwala.
EC to advocate intervention.
Sorry.
EC to advocate intervention.
AC to Advocate Indrajit Sinha submits that the notice has not been served upon the respondent number 5, but in the connected case, she has been appearing for respondent number 5, and therefore she will seek instructions and file wakalatnama on behalf of respondent number 5. The private respondent number 6 and 7 are present. Is present. Counsel for the state is also present. The matter relates to the manner in which the rent has been fixed. Considering the nature of dispute, let the counsel for the state आप produce करेंगे? कौन produce करेगा? Let the records be called for a photocopy of the records.
Record call कर लिएगा.
A photocopy of the records be called for from the court of subdivisional officer Giridih Sadar relating to execution case number 6 of 2017 decided on 8/3/2018. Then divisional commissioner not appellate order कहाँ है? Appellate order?
Yes, but that is at page.
Appellate order passed by the learned deputy commissioner in house rent appeal case number 3 of 2013, and the revisional order passed by the commissioner North Chotanagpur division Hazaribagh in house
59/2018.
House Control Revision number 33 of 2017. Who is this case on? आप बताएं date.
Any date was issued by friends.
Okay, आप बताएं. You tell us.
Any date was 15th of
Post 15th.
We don't have some time.
Who is this case on 29th of October? No, 24th of October 2024. In the meantime, the आपने counter file कर दिया?
Yes.
In the meantime, the respondent number 5
Yes.
may file the complaint.
I will also file.
You provide
Because I have
provided
not
the copy of it.
My lord, otherwise, my lord, the order dated 27/8/2000, I have been restrained to construct that order.
So the disposal.
अब इसमें क्या है? तो कुछ नहीं है.
And
Interim orders उसमें है ना? Interim order stands vacated so far as that particular part is concerned. तो उस रीत में तो उसी रीत में ना interim order.
But that date not is disposing of.
Yes, that of course.
So that everything goes.
Interim order pending applications are also closed. अभी और भी होगा एक आध petition अगर होगा.
Item 14, WPC 2880 of 2018.
Lord, in this case, we have copy of both the IE and the served in the court.
This is for orders.
Yes,
Why for orders?
My lord, we have filed one IA, my lord,
For
for restraining the ECL, my lord, Eastern Coalfield Limited, who had acquired, my lord, the.
have you seen the office note? Have you seen the office note? नहीं देखे हैं तो लिखिए. WPC number 2880 of 2018. The learned counsel for the petition submits that he has not been able to see the office note. Was this case on 21st October? ऑफिस नोट देखना आप लोग का काम है, मेरा काम नहीं है कि हम आपको ऑफिस नोट पढ़ के बताएं. चलिए नेक्स्ट.
Tomorrow पर रख दिए.
नहीं हो सकता. अभी क्लोजिंग
Item
टाइम
15,
है.
WPC 567 of
अर्जेंट मैटर
2018.
था और हम लोग दो मिनट सुन लिया जाए.
आप ऑर्डर ही अभी नोटिस सर्विस नहीं हुआ है इसमें. आप जरा देखिए तो एक बार नोटिस सर्व नहीं हुआ. आप लोग ऑफिस नोट
तो
नहीं
नोटिस
देख.
कर दिया जाए मैडम.
हम नहीं जानते हैं, आप अपना ऑफिस नोट नहीं पढ़िएगा तो हम आपको पढ़ के नहीं बताएंगे. Yes, petitioner.
Yes, Your Honor.
Why is it listed for orders today?
There are 3 IAs that is to be heard, Your Lordship, 2 filed by them, 1 filed by us.
Notice has not been served in
No,
this
it
case.
has been, they have filed wakalatnama, Your Lordship.
Just a moment. Six B has not received. 6B notice has not been served upon 6B. Your file wakalat, who has filed wakalatnama?
Malord, respondent number 6A and B both. Malord. Since
A and
power
B
has
both?
been given by B to Malord 6A. Malord.
Where is the power? Have you stated so that you are representing 6A and B both? If you are,
Letter of authorization should be there, Malord, because respondent number Malord 6D has authorized his mother, Malord, to contest in this matter.
letter of authorization. Where is it? Have you mentioned it? You file an affidavit. Because
Malord, we have-
ultimately any order passed by this court will bind her also.
Malord, prior to this, Malord, we have filed one application under section under order 1 rule 10 for impleading Malord the respondent's party respondent in this matter. By way of that application, Malord, that application, IA application was treated, Malord, as an information to the other side. Because, Malord, during the pendency of the writ application, Malord, the respondent number 6 had died. So, Malord,
I want to know
so,
whether
Malord,
what is the problem in filing wakalatnama of respondent number 6?
we have filed the wakalatnama.
You have filed wakalatnama only on behalf of one person.
And another person had authorized, Malord, so we have already filed earlier, Malord. We have already earlier filed.
You show me the wakalatnama of respondent number 6B from there.
Malord, may I kindly see the IA application?
IA number? What is that IA?
I'm just
IA number please.
Malord, the IA number is Malord. IA number is Malord 1333 of public 2021.
1333.
No, sorry.
448 is not the content application.
Malord, IA number 7048 of 2021.
7048.
Of 2022.
7048. Just a minute. Okay, baat mein ऊपर इसको ऊपर होगा. कहाँ है ठीक? सेवन वन टू थ्री है 7048 तो लिखिए. कौन से ऑर्डर से डिस्पोजल हुआ?
Malord, 15th of March 2022.
सेवन 7048. This contains the वकालतनामा of 6A and 6B.
Malord, Malord 6B का तो authorization दिया हुआ है.
Authorization ऐसे नहीं होता है ना, इस तरह से नहीं होता authorization. You file the वकालतनामा. और यू फाइल पावर ऑफ अटॉर्नी. ऐसे ऑथराइजेशन नहीं कर सकते.
ठीक है, वो तो फाइल करें, ऑथराइजेशन हम तो
आप
लगाए.
फाइल कर दीजिए. व्हाट्स अ बिग डील? शी इज अलाइव, नो?
No, my lord. Actually, he is residing outside. My lord. Therefore,
मदर?
mother is there. Mother has filed our color.
नो. यस हो सकता
My lord, in paragraph 5 of the
है. नहीं हो
IAP.
सकता है ऐसा. नहीं हो सकता. Either it can be through a power of attorney or it can be through country.
And we have 5 my lord authorization.
आपको वकालतनामा कहीं भी हो, आप उनसे वकालतनामा मंगा लीजिए. बाहर भी रहते हैं तो क्या है? It's not a big deal. A person can sign वकालतनामा anywhere.
Yes, ma'am.
It is required to be filed.
Yes, Your Lordship, may please just have a look to the order dated 15/3/22,
Yes.
which my learned friend is relying. That itself has clearly stated everything. The present interlocutory IA number 7048 of 2021. The present interlocutory application has been filed by the applicant such and such, widow of late such and such, under order 1 rule 10, read with section 151 CPC, for impleading the legal heirs of respondent number 6, who has died during pendency of the writ petition on 24/9/2021, by adding her and one son, namely such and such, in his place. Having heard learned counsel for the parties, the present interlocutory application filed by the applicant is to be treated as information to the petitioner, so as to file an appropriate application for substitution of the respondent number 6
He will file it.
with his.
He will file वकालत.
And before Your Lordship goes to that, please just have a look to our IA application 7123 of 2023. Seven 23 of 2023.
We will hear that. We will hear that. Let him file it. WPC number 5672 of 2018. That will counsel appearing on behalf of respondent number 6 within bracket A submits that respondent number 6 within bracket B is the son of respondent number 6A, and he shall seek instructions and file wakalatnama on behalf of respondent number 6B,
Yes.
and no fresh notice be issued.
Yes, no need.
How much time do you need?
2 weeks.
Have you responded to this IA number 7?
Yes, ma'am.
You have filed your response?
Yes, ma'am.
Post this case on 28th of October. The needful be done by respondent number. The needful be done by filing wakalatnama and stroke or and also counter affidavit, if any, to the main writ petition and also to the interlocutory application.
Main writ petition will be filed.
No, on behalf of 6B. Either he will simply
Yes,
say
ma'am.
that he will adopt.
Adopt, yes, ma'am.
By 23rd he will tell you.
Like.
For admission item 16, WPS 7063 of 2012.
Yes, petitioner.
Possible for frequency.
It's already 1 o'clock.
My senior Mr. Manoj there was also a direction on 13/9/2022 to file an affidavit Just a few cases you will pass over.
We already have a couple of passover matters. Respondent number 2.
Yes.
Have you filed your affidavit?
Yes, it has not been filed, but I am not the main party, my lord. The petitioner is the main party.
The respondent number 2 was directed to file an affidavit.
Yes.
Have you
Yes.
filed it or not?
No, it has not been filed.
Why have you not filed?
Because as per the order, my lord, impleading order also, my lord, I am the contractor, my lord. Petitioner was the principal employee, my lord. Whatever
There
about
was a direction to file affidavit. Whatever you have to say, you say it on affidavit.
2 weeks time will be.
This was on in the year 2022, right? WPL number 7063 of 2012. Counsel for the parties are present. Counsel for the respondent number 2 submits that since the respondent number 2 is the contractor,
My lord.
therefore he has not filed the affidavit. However, he prays for some time to comply the order dated 13th of September 2022. Let the affidavit of respondent number 2 be filed in terms of order dated 13th of September 2022 by 18th of October. Post this case on 14th of October. No, 14 नहीं होगा 21st, sorry. 21st, it will come on 21st. 18 तारीख को टाइम ही नहीं.
Item 17, WPL 3188 of 2014.
Petitioner. Where is the petitioner? Mrs. Pal is scheduled to come in the second half, right? We'll take it up in the second. आज भी तो बीसी में तो आवाज ही नहीं आती है. आप बीसी ठीक कराइए, बीसी ठीक कराइए. We will decide. इसमें Mr. M.K. Laik is the arguing counsel. Yes. BCCL is there. You are the respondent in this case. Where is Mr. Laik? Where is MS Patro? Why are they absent? Nobody appears for the petitioner. Counsel for the respondent is present. Post this case.
Names of none of the counsel from the side of respondent is appearing.
But
Probably
you
earlier.
can down. I'm fixing a date.
Oh yes.
Mr. A.K. Mehta appears on behalf of the respondent BCCA. You have been appearing. No. But you had appeared earlier. You had appeared on 18/6/24. Your name is. Office is directed to provide the soft copy to you.
Yes, ma'am, that would be okay.
It was already there. That
It is
order is
already
already there. It has been complied.
But
Soft copy has been provided to you on 18/6/24 के आसपास का अपना mail check.
ठीक है, वो check.
Since the petitioner is absent, post this case on 15th of October by way of last indulgence. At the request of the counsel for the at the request of Mr. A.K. Mehta, office is directed to print the name of Mr. A.K. Mehta from the side of the respondent. Do you file wakalatnama also?
That will not be required.
Item 18, Chalu PL 4916 of 2014.
In this matter, we have to reconstruct the file. We don't have the file.
The state doesn't have the file.
Yes, sir. It's a very old matter. Earlier, it was in somebody else's jurisdiction.
You have been appearing on time and again. You have appeared on 4th of September 2024, 20th of August 2024. You were appearing without the file.
Yes, leadership, we appeared at that time without a file, and IA was filed for substitution leadership on the last time, and it was allowed at once. Respondents filed the IA leadership.
An excuse for not arguing the case. You don't have the records.
I have requested leadership, advocate for the petition, respondents leadership to hand over the file.
There is an order of reinstatement.
Yes,
You're telling me that
reinstatement and the arrears of salary also leadership.
it's
We have challenged the
25F.
order dated 7/2/2014.
It is 25F matter.
But our contention is leadership that we don't come under the Industrial Disputes Act leadership. We are facing that argument in our leadership. That I have read.
The departments of the government
Yes.
which are engaged in construction activities, etc., they do come under industrial disputes.
That is our argument leadership in the.
They do come.
On the next step leadership, I will do this matter.
You are not discharging sovereign functions, are you? While employing
That
this.
the project leadership ended in 1990 only, and that time retrenchment was done leadership. And since the project was
Water
ended,
Resources Department,
yes, leadership.
is it discharging sovereign functions? They are engaged in so much of projects, engaged
The
in so many
project was
people.
over leadership. That's why they are.
That is a separate thing.
Yes.
When you say that it is not covered by Industrial Disputes Act, so you are pushed for something.
On the next step leadership.
किसके एड्रेस में देंगे, किसको मेल करना बताइए. WPL number 4916 of 2014. I do not know. Whosoever is the concerned counsel. Abhijit Kumar Singh is the concerned counsel.
No, leadership. We have for the state Lordship Sachin Kumar.
Mr. Sachin Kumar.
Yes.
You give his mail ID. MS, your name?
Shweta Shukla leadership.
Shweta Shukla. AC to Mr. Sachin Kumar.
AG2.
AG2 submits that she does not have, that her office does not have a copy of the brief, and therefore they are unable to argue this case. She has also submitted that the core issue involved in this case as to whether the Water Resources Department of the state of Jharkhand would be covered under the Industrial Disputes Act. Office is directed to provide a soft copy of the entire records of this case to Mr. Sachin Kumar at his following email ID. Provide his email ID, his phone number. The records have already been received from the concerned court. Baki, the case is otherwise ready. Post this case under the heading for final disposal on, you choose a date. You ask him and choose a date.
Yes.
You ask him. Right? You ask him, when will he do it? You give a date yourself.
Okay.
5-7 मिनट में आगे डेट बताइए कब तक.
Item 19.
Nobody appears for the respondent.
Item 19, WPL 193 of 2015.
In this matter, we have to reconstruct the file.
My lord, this petition has become infructuous. Petition related to transfer matter, my lord, and the opposing party, my lord, for which I am appearing, my lord, he has already retired in 2017.
Yes. This is an infractuous case. Who is your senior?
Mr. Sivkumar Sharma.
Sorry?
Mr. Sivkumar Sharma.
Shiv Kumar. You ask him to go through the thing. He says, is there any consequential relief given
Yes,
to
yes,
that?
retirement benefits have been withheld. Only on ground of this petition is pending, all retirement benefits has been withheld.
ऐसे नहीं चलेगा ना
Yes, ma'am.
रिटायरल बेनिफिट विथहोल्ड कर दीजिए और उसके बाद फाइल घुमा दीजिए
Madam, we are signing this matter last week, so we don't have the.
We don't know. Union of India is one party.
Yes, ma'am.
For compliance, what was the compliance? Which compliance? आपके पास ब्रीफ है ना? कॉपी दे दीजिए कल सुन ठीक है कल नहीं 3 तारीख को ठीक है WPL number 193 of 2015 at the request of the counsel for the petitioner the learned counsel for the private respondent has provided a copy of the brief to him so that he may get ready. The learned counsel for the respondent has submitted that the case has become infructuous. The matter relates to transfer and the respondent has already attained the age of superannuation. But on view of the pendency of this case, the post-retirement benefits of the petitioner has been withheld. Post this case on 3rd for final disposal, no further adjournment will be granted.
Item 20, WPC 3423 of 2015.
Lordship, I wait for general for being for us. My senior Mr. Gloria is before Honorable DB1 reports.
What is the matter?
My Lord, this pertains to grant of interest subsidy as promised by the state in terms of Jharkhand Industrial Policy 2001 by virtue of clause 29.5.
Numerous orders have been passed.
My Lords,
Numerous orders have been passed.
numerous orders in that regard may have been passed, my Lord, but then our case is that despite they being promising as per clause 29.5 and also by virtue of another policy, my Lords, they still are not giving us the subsidy
Is
for
there
interest
any
benefit.
improved order or rejection? There was an interlocutory application.
Because an IA was filed on
Amending the
our behalf for amending the petition because there was an order which was brought to our notice by the
You
state.
have filed your amended petition.
We have filed our
here
amendment.
in this particular petition also.
My Lords, in all the
3430 of 2015. Have
My
you
Lords,
filed it?
yes, my Lords. In all 5 petitions, my Lord, we have filed our amended.
You have not filed your counter affidavit.
My Lords, in few of the cases they have filed. In 3423, 3431, 3432, they have filed the counter. In 3430 and 3433, it has not been filed.
There is a direction that if by the next date the counter affidavit is not filed, then the concerned person will remain present physically. Where is the concerned person? Some time. You will not even open your mouth. That there is a direction for personal appearance. Neither the petitioner nor the respondent. He wants adjournment.
Some other associate was allotted this matter in office petition. I was not allotted this matter.
This order is not uploaded.
No, Ladyship, I am not saying that, Your Ladyship. Since the matter has been called, Ladyship, the associate which was allotted, who was allotted this matter, he is in court 1, Ladyship. That's why it was allotted to him.
You are appearing by proxy.
Since the matter got called, Ladyship, that's why I appeared.
So what about the counter affidavit is not filed? then the authorized person shall remain present. Who is the authorized person? Who has filed counter affidavit in other cases?
My lord, sir.
To the Secretary, Department of Industries.
Yes, ma'am.
So he has to come. When will he come? When will he get time to come? When? Confirm. Because now he has to appear. There is a judicial order. We don't change judicial orders by verbal orders. There is a direction by a coordinate bench. He has to appear.
Leadership, I am taking the instructions, leadership, after few cases, leadership, and this matter will coordinate.
You call your counsel.
Yes,
In the second half. This person has to come. Isn't it?
yes.
Or you can call him in the second half also, no problem. You can call him in the second half. The secretary can come in the second half. It's just half an hour away. Right?
I'm sorry, my lord. In item number 18, my lord, I was appearing for the workman, my lord, in whomsoever the award has been passed.
So, what have I done?
My lord, the final date disposal.
I don't know.
He is the respondent in leadership that matter.
Item number 8.
We do not know. We have already passed on. तो डेट हुआ होगा मुझे थोड़ी याद है.
हाँ. डेट बताने के लिए कहा.
हाँ? अच्छा डेट बताने के लिए कहा.
जी जी.
कौन सा डेट रखना बताइए.
My lord, if possible tomorrow, my lord.
No, leadership, senior will argue this matter, leadership, after vacation.
Tomorrow नहीं हो सकता.
ठीक है.
वो water resources department वाला ना.
Yes, yes.
You were supposed to tell me the date.
Yes,
Wait, what is the date?
Leadership, I was about to ask him over it.
Why do you need to ask him? Your counsel is not available most of the time. He's only seeking adjournments. So I just wanted to know from you when will your
Leadership after
counsel
the vacations, leadership.
if you will not fix a date, no. I'm asking you to tell me a date. You ask him
18th October, leadership.
18th October को. 18th. रिकॉर्ड आ गया उसका? रिकॉर्ड आया है?
नहीं leadership अभी तो फाइल. I will give the email address and then.
नहीं देखिए तो रिकॉर्ड आया है इसका. It's here.
रिकॉर्ड आ गया.
ठीक है. Records have already been received,
Yes.
right? So there is no reason for any adjournment.
Yes.
18th October
18.
for final disposal.
Of right.
Item 25, WPC 5851 of 2015.
Yes.
Your Lordship, I am praying for 2 weeks' time, Your Lordship, in this case.
For what?
The arguing counsel is admitted in hospital right now.
Who's the arguing counsel?
Arvind Kumar Sinha. He suffered from heart attack on 17th.
71A.
I am on behalf of respondent number 4, Your Lordship.
You are representing whom? आप किन की तरफ से?
Myself.
Petitioner.
On behalf of the petitioner.
You are also seeking time. आपको भी टाइम चाहिए?
नहीं मुझे टाइम नहीं चाहिए. petitioner के तरफ.
अब ये तो बीमार है क्या ही करें बताइए? There is a direction for restoration of possession. Who is it for? The learned counsel for the parties are present. Counsel for the private respondent.
Yes, sir.
Praise for adjournment. By submitting that, the arguing counsel is, unable to appear before this court on account of his personal difficulty. When should I post it?
After your patients.
After he had suffered a heart attack.
Ma'am,
Will he be able to come after Durga Puja?
after
You
the
need
work,
more
after
time.
the work.
Post this case on 18th of November 24. In the meantime, record मंगा लेते हैं. Record आया है? नहीं आया है? आया है? In the meantime, let the records be called for from the concerned authorities. तीनों का लिख देंगे. SAR कोड नंबर बताइए, सब नंबर लिख के दीजिए. कहाँ का केस है? रांची का केस है? SAR कोड का, एपिलिस कोड का एंड रिवीजन कोड.
नंबर लिख के देंगे, सब केस नंबर.
लिख कर दे देते हैं. Passover case, item 5, WPC 5781 of 2016, along with item 6 to 9.
I am praying for not to perhaps my senior Mr. P. Singh mentioned the matter on Friday that the respondents mentioned without giving the information he is out of station, my lord. And on Friday he mentioned the matter before my lord and prays for no.
Only one thing I'll point out, otherwise whatever date may be fixed. Now they are enjoying stay at least in two matters since last 13 years. In 11-12 also the writ petition was filed. Stays.
You want not today, no?
Yes, my lord, it may be kept on Friday.
Not on Friday, on 3rd.
On?
3rd. Friday will be last working day.
Last working day.
It
So
will
at
be
least
on 3rd. But at the same time,
Yes, ma'am.
they have challenged the provision.
Yes, yes. Your Lordship may kindly take up 5781 of 2016, all the almost identical matters where they have challenged the MDG guidelines. Several high courts have already dealt with the matter.
Show us the judgments.
Yes. all
And
of
provide
them
it
are
to
there.
them also.
Yes, yes.
So, you see,
In many cases,
since you have challenged the guidelines, therefore the matter is there in the report. Right? If the guidelines are quashed, the matter ends, you win. If the guidelines are upheld, then you will have to avail the alternative. That's it. So these are the various judgments. I think we have also dealt with it.
Your Lordship have heard this matter.
फिर क्या हुआ? फिर adjourn.
No, but finally it could not be disposed.
I think I decided it. No.
Manoj have dealt it extensively, but Manoj, the petitioner, I think on that date also had taken time, and thereafter it didn't come.
You have given them the list. Provide them the
One
list
thing
and
can I do, Your Lordship, with Your Lordship's permission, because I had highlighted my own
You please do that for
judgments.
me also.
That would be convenient.
Yes, yes, please do that. वो करके हमको दे दीजिए.
हाँ.
ठीक है?
Where
अब आप तैयार हो जाइएगा.
Yes, ma'am.
टाइम मत मांगिएगा, नहीं तो स्टे वेकेट कर दीजिए. ठीक है? WPC नंबर 5781 of 2016. Mr. आपका नाम बोलिए.
Jagdish.
Jagdish submits that the arguing counsel, Mr. Rupesh Singh, is not present in the court, is not available to argue this case today. He submits that the matter be posted on 3rd, post on 3rd. For final disposal?
Yes, ma'am.
Final disposal. We have a few passover matters.
Passover matter item 10, WPL 7084 of 2019.
We have received a report that none of the check has been encashed.
I have seen that. I have seen that report. This is at flag R. And checks were deposited. Informations were given to the union as well as to the workmen, but none appeared. So that is why we are saying the genuineness of these persons are doubtful. Because one of the plea that has been raised by us before the Supreme Court is that the checks be disbursed.
I want to know. Give me 2-3 dates.
Sorry.
Give me 2-3 dates One is
Yes,
the date of the order by the Honorable Supreme Court. Date of the order.
order. There are two orders of the Supreme Court. First is at page 40, that is 28/11/2016.
Then
Just a minute. Sorry, the first is 7/11/2016 at page 35. The second is 28/11/16 at page 40.
page 35. Now these people were party before the Supreme Court.
Yes, these criminal act, what happened was, there is an award. Award has attained finality. We didn't implement it, so a prosecution was launched against us. So against that
They
prosecution,
launched the prosecution. They are
They-
private
no.
parties.
it was, prosecution is always launched by the Office of the
Enforcement
Regional
Officer.
Labour Commissioner, under the Act, the authority responsible for getting the award implemented. So that we filed an application for quashing of cognizance that was dismissed. Against that we went to the Supreme Court. So the first order is the order at page 35. Sorry. My lords, I'm sorry, there's a third order also. That is at page 28, annexure 2. That is in fact the first order. This is 10/2/2009. Now when my criminal washing application, CRNP, was dismissed on 17/8/2007, we filed a SLP before the Supreme Court, that is SLP criminal number 3546 of 2008, and 10/2/2009 is the order. Issue notice on the application for stay. In the meanwhile, there shall be stay of further proceedings in ID case number 71 of 19.
That is a criminal case first.
This is, all three are of the same case.
Then
Then, the second order is at page 35. Page 36. We have heard learned counsel for appearing for the parties and have also gone through the records. The petitioners hearing have challenged filing of the complaint under section 29 of the ID Act for non-implementation of award by Bharat Coking Coal Limited. Learned counsel appearing for the petitioner state that the petitioner shall implement the award by depositing the requisite amount payable under the award with the central government industrial tribunal within 2 weeks from today. He submits that the said amount can be disbursed to the workmen subject to their verification by this central government industrial tribunal. So pursuant to this, page 37, we deposited those checks, 8 in number, totaling rupees 40 lakhs, which was accepted by the CGIT, and which is the report also that your Lordship has seen. Then finally, the matter is taken up by the Supreme Court on 28/11/16, page 40, and the order is, affidavit is filed by the petitioner inter alia stating that in order to show it's bona fide to implement the award passed by the central government industrial tribunal, Mrs. BCCL has deposited a sum of rupees 5 lakhs in respect of each of the workmen. It is further submitted that actual amount payable under the award can be computed by CGIT in the proceedings under section 23C2 of the ID Act 1947, and the petitioner has no objection if the same is done by the CGIT expeditiously. In view of the aforesaid deposit by BCCL, the award substantially stands satisfied. We record the undertaking of the learned counsel for the petitioner that in case the amount deposited is found deficient in respect of any workman, the said deficiencies shall be made up by the company. We also observe that CGIT shall refund the portion of the amount which is found in excess of the actual amount payable to a particular worker, since it is an old matter and whereabouts of the workman may not be easily available. All the parties, including BCCL, shall cooperate with CGIT for service of notice of the workman. In view of the aforesaid, the criminal proceedings initiated against the petition stands quashed. So this is ultimately the final order.
The notices were issued, they did not appear, nothing happened. They remained pressless. The checks were not encashed.
Yes, this
So,
is the
so
position.
technically there is no deposit.
No, the deposits were made.
Check is not a deposit.
No, the court directed us to deposit in that manner.
Check is not a deposit.
No, but your Lordship has seen that.
But ultimately, what
Yes,
stands
yeah,
today
is that the
there is
amount
no
has
deposit.
not been disbursed. So
And they have filed their petition under section 33.
33C2, and our objection was with regards to their identification number 1, that these persons were never identified because in the award
Now-
only the name was there.
Now let us see what is the impugned order here.
Yes. That your Lordship will
And
find.
what is the nature of jurisdiction or whatever you are challenging? Jurisdiction we will not do.
No, I'm not saying so, because your Lordship has already held in that review
Yes.
that they have concurrent jurisdiction, it can be presented anywhere.
That's right.
Now the issue is, have these persons been identified or not?
Let us see. You must have disputed their identity.
Yes, we
Let
have
us see.
disputed it.
Let
Kindly
us see how the court has dealt with it.
No, firstly, kindly see our response to the notice in the written statement, how we have dealt with it.
Yes.
That starts at page 32. Yes, this is the written statement that is filed in this 33C2 application. And kindly turn to the next page. Paragraph, these are the names that is only there in the award. The first name is only there. Then the management filed writ petition before the.
Srimati Munni.
Yes, here
Her name
is
is there?
Srimati Munni is there.
Yes.
Serial number 4.
That's
Right. Then kindly come to paragraph 9. That subsequent to the disposal of the SLP by the Honorable Supreme Court of India, the management initiated action to implement the award, and accordingly the awardees were called upon to submit their identification roll in the prescribed format. 10. That the Honorable Supreme Court of India in the judgment reported in so and so in the case of inquiry in relation to management of Earth Cooking Coal Limited versus Raghunath Valmiki and others held that only the genuine beneficiaries of the award should be reinstated as per award and make the payment of damages. The Honorable Supreme Court also prescribed a format which should be filled up by the beneficiaries, and thereafter the management complete the verification process. That while letter dated 3/12/99.
Let's pause for a moment.
Sorry.
This Raghunath Valmiki's case was arising out of the same award.
No, it is not from the same award. It is only in relation to matters where identification is involved.
Okay.
Because here it is only the name that is there.
That's right. Kindly continue.
May I forward that judgment to your Lordship?
Yes.
Yes. Then, my lord. Paragraph 11. That while letter dated 3/12/1999, the management supplied the copy of format to the applicant with a request to submit the format duly filled up and signed in proper way within a fortnight of receipt of letter, but the applicant has not submitted the format along with relevant documents for identification and verification. That by letter dated 27/2000, all the awardees were called upon to appear on 24/7/2000 at 3 p.m. for verification of the form and interview on 14/7/2000. That despite information given to the awardees, none of the awardees, including the applicant, have turned up. That until and unless the awardees turn up, before the employer for their identification according to the format, prescribed by the Honorable Supreme Court in the case of so and so, the applicant is neither entitled for reinstatement nor entitled for back wages. That in absence of name, parentage, address, age, and photograph, it is difficult to identify the genuine beneficiaries. That even after publication of award, the sponsoring union has not verified the identity of the workman concerned in reference case number so and so. That again the management issued notice to the beneficiaries of the award by notice dated 18/2010 for submission of prescribed format for identification, but in spite of that the applicant has not submitted format to the management for his identification. That meanwhile the Assistant Labour Commissioner, then that ID case.
That's right. Then what happened?
So this is it. And then kindly come to the order passed by the
Has he
Labour Court.
entered
Yes,
into
yes.
the identity?
Yes, yes, I'll just take you one second. It starts from page 47. May I read this paragraph 3? It's a long paragraph, but it has taken note of that. On notice to the opposite party appeared through his learned counsel, and then the written statement is there. I've already read. Then all these facts are coming up, including about 7-8 lines from the bottom. Until and unless the awardee turned up before the employer for their identification, according to format prescribed by the Honorable Supreme Court in the case of so and so, the applicant is neither entitled for reinstatement nor for
That is your stand.
by stand. Then kindly,
Para 4. You read from para 4.
para 4. Yes. Altogether, 2 witnesses, namely Muni, alias Mani Kamin, applicant herself, and Satish Prasad Bandal, union representative, Bihar Colliery Kamar Union, have been examined on behalf of the applicant. AW1 Muni, alias Mani Kamin, has deposed that she has filed the instant case against the Chief Manager Mining for implementation of award passed in F case number 68 of 83 by the Central Government Industrial Tribunal number 1 Dhanbad with effect from 19th September 1983. In her deposition, she has supported her case. Satish Prasad Mandal, who is the union leader, belongs to Bihar Colliery Kamgar Union, supported the case of applicant. In his cross-examination by para 23, he has stated that industrial dispute was raised by Bihar Colliery Kamgar Union. At that time, one Dipendu Mukherjee was secretary of Bihar Colliery Kamgar Union. The case was handed over to Dipendu Mukherjee, and that was operated by him. In that case, the name of the applicant was mentioned, but his parentage was not mentioned. By para 27, he has stated that the concerned workmen were working since 79-80. He is the official of the union. He has no knowledge that in which year he was elected as branch secretary. His name was mentioned as branch secretary of the union. He was not nominated by Arup Chatterjee and branch secretary, but he was nominated by S.K. Bakshi. By para 28, he has stated that it is not true, that at present he is not working as branch secretary of the union. BCCL is a public sector unit of central government. Any kind of case relating to units established by central government is maintainable in labour courts, and documents have been marked as exhibits on behalf of the applicant. Your Lordship will kindly turn to the next page. Your Lordship will find marked as X12. There is one document at page 50. These are not exhibit, but it is marked as X12 for identification. This is photocopy of format duly filled up and signed by the applicant. So, identification matter comes up. There is a document which is marked X12 for identification, not as an exhibit. Then kindly see. One Mundrika Yadav has been examined as sole witness on behalf of the opposite party. In his affidavit statement, he has deposed that he is posted as clerk at Govindpur Colliery. The industrial dispute was raised by one Dipendu Mukherjee, Secretary Bihar Colliery Kamgar Union, which was referred by the Government of India to Industrial Tribunal number 1 for identification and registered as reference case number 68 of 83 by the tribunal. The tribunal-wide award dated so-and-so has been pleased to pass the order of regularization of 8 persons, the names are there, due to missing of parentage, residence and age in the said award and non-submission of details by the applicant and his identity, the same could not comply with. Once again on 1810 to 11/2010, the management requested the applicant to submit the necessary information by filling the prescribed format within 15 days, but they failed to do so. The applicant did not claim as beneficiary of award passed by the CGIT. The management of BCCS has already deposited the amount of Rs 5 lakh in respect of each workman in the Central Government Industrial Tribunal number 1, Dhanbad. A notice was issued to Bihar Colliery Kamgar Union for identification of workmen, but nobody present on the behalf of union as well as concerned workmen. In his cross-examination, by para 9, he has stated that he is working at Govindpur Colliery since 2000. By para 11, he has stated that he knows Satish Prasad Pandey. He has knowledge about the spot verification by Labour Enforcement Officer Bagmara on the instruction of Assistant Labour Commissioner Dhanbad. He has no knowledge that in compliance of spot verification, the concerned workmen were identified. He has no knowledge that whether the said LEO was deposed before the tribunal or not. He is conversant with the record. He has no personal knowledge by para 14. He has stated that he has no knowledge that all the necessary relevant papers have been submitted by the concerned workman.
You see, the concerned workman here is coming,
Mile.
right? He or she?
She.
She has been examined?
Yes, one.
Cross-examined?
Yes.
Show us.
Paragraph 4. Yeah, I just read paragraph 4 of this order.
Yes, it does not refer to cross-examination of PW1. This para 4 of this lady has been cross-examined.
Altogether, 2 witnesses, namely Muni. So she is the
AW1 Muni has deposed. AW1.
Yes.
Right? AW1 is Muni.
Muni.
Yes, she has deposed. Where is her cross-examination?
There is no discussion about the cross-examination. There is some discussion. This is by Mandal. So for her deposition, I do not find anywhere.
Her deposition is there, but there is no cross-examination.
All right.
So, her identity remains intact. She claims to be one of the beneficiaries, subject to you see the records.
No, if it is there, your lordship has seen it, I do not
No,
see.
नहीं, आप लोग देखिए।
नहीं, आप देख लिया
देखिए
ना,
हम
I'll accept
ऐसा
it.
है, देखिए कुछ एरर हमसे भी हो सकता है। आप एक बार देख लीजिए। यही है क्या एविडेंस की क्या है? या इसके अलावा कुछ?
No, this is only an affidavit.
या एफिडेविट?
This is not. This is not
एविडेंस होगा इनका निकाल लीजिए।
evidence only.
वहाँ कैसे करते हैं पता नहीं एफिडेविट।
नहीं, ये तो
एफिडेविट है।
अच्छा, और देख लीजिए। आप चेक करिए उसका।
इंडेक्स
Because it says that she has been examined as a witness.
Deposition, evidence by the applicant, 74.
चेक करिए। उसको पढ़िए और उसका क्रॉस एग्जामिनेशन।
हाँ.
हाँ।
Yes, it is
बस
there.
उसी का एविडेंस पढ़िए। He is the
Satish
applicant.
Kumar Mandal.
नहीं। We are talking about Muni. And is there any finding regarding her identity?
No, there is no finding. What he says ki identity is established. I can do that. Even under 33C2.
Yes, identity you can. So when any spurious person files under 33C2 saying that there is an award in my favor.
I have got it.
Cross.
चीफ क्रॉस दोनों पढ़े, साथ में पढ़े।
यह कि यह बात मैंने दायर किया है, यह कि यह बात BCCL के गोविंदपुर कोयलेरी के मुख्य प्रबंधक गणन के विरुद्ध दायर किया हूँ, यह कि केंद्रीय सरकार औद्योगिक अभिकरण संख्या 1 धनबाद द्वारा पंचायत पारित किया गया था, जिसमें दिनांक 19 सितंबर 1983 से बकाया वेतन राशि का भुगतान का आदेश पारित किया गया था, जिस पंचायत का निर्देश संख्या 1600 है, यह कि पंचायत निर्देश संख्या 68 ऑफ 83 के आदेश के विरुद्ध प्रबंधन द्वारा पटना उच्च न्यायालय रांची रिट पिटीशन इज एन स्किप माय लॉर्ड्स, सुप्रीम कोर्ट हो गया यह कि उच्चतम न्यायालय द्वारा अपील खारिज होने पर पंचायत पूर्ण वैध हो गया है तथा इस बात के बकाया वेतन राशि का दिनांक 19/9/83 से 30/11 तक का दावा दायर किया हूँ। जो उपबंध A एंड B की प्रवृत्ति के 3 में दायर किया हूँ, यह कि पंचायत पूर्व पारित निर्देश संख्या का पुष्टि किया गया है तथा यह आवेदक का दावा सही एवं न्याय संगत है, यह कि मैंने उपरोक्त लिखित बयान को पढ़ा सुना सही पाया, यह कि मैं आवेदक शपथ पत्र बयान माननीय न्यायालय ने उपरोक्त वाद को विपक्षी के विरुद्ध विविध क्षेत्राधिकार वाद के तहत निर्धारण एवं भुगतान पाने के लिए दायर किया हूँ। क्रॉस एग्जामिनेशन आवेदक साक्षी संख्या 1 मानी कामिनी पति स्वर्गीय 1660 वर्ष दर्शन ग्रहणी का यह बहाली BCCL में कब हुई याद नहीं है, नौकरी से कब निकाला गया मुझे याद नहीं है, मेरे पास बहाली व नियोजन का कोई कागज नहीं है, कंपनी के द्वारा नौकरी का परिचय पत्र नहीं है, मुझे शपथ पत्र में वर्णित तथ्यों की जानकारी है। इस केस से पहले भी एक और केस चलता था, उसकी जानकारी मुझे है। ऐसी बात नहीं है कि आप सही कभी कोई किया है।
What document have you produced to establish her identity?
So there are 2 documents which have been marked Exhibit 12, X12. No, not Exhibit, it has been marked for identification X12 and X13. One is the format which has been filled up and submitted by her. And
She has not stated that she has filled that format. She in her evidence is not referring to this. She has not stated.
She has said कि हम नौकरी कर रहे थे,
नौकरी का कागज नहीं है। She has said कि मेरे पास नौकरी का कागज
मेरे पास बहाली वह
ये कौन एग्जिबिट किया है? ये 12/1
एग्जिबिट मार्क फॉर आइडेंटिफिकेशन फोटोकॉपी है।
कोई तो प्रोड्यूस किया होगा ना, कौन प्रोड्यूस किया है?
हाँ, by the workman I think by the applicant only. In the order, all exhibits have come. At page 49, some documents have been marked as exhibit on behalf of the applicant. उसी list में आ रहा है। Applicant is the worker. All these are at her instance.
Rather, there are specific cases that she never responded to it.
But here the exhibit 1 is the letter by which she was called for interview. That has been marked exhibit because original was produced. This letter is issued by BCCL.
This letter was produced on behalf of the workman.
On behalf of the workman. Appearing for interview. Exhibit 1.
This original has been produced, isn't it?
Yes.
This is dated 31/10/2000.
Yes.
When was she appointed?
No, her appointment was prior to Lordship 83.
What was this letter for?
मेरी बहाली BCCL में कब हुई याद नहीं, नौकरी से कब निकाल गया मुझे याद नहीं, मेरे पास बहाली व निकासी का कोई कागज नहीं, कंपनी के द्वारा नौकरी का परिचय पत्र नहीं है।
So that is going behind the award. The award has to be seen.
No, she is taking her deposition.
No, I just wanted to know what all are the documents to establish her identity, because identity is a crucial question.
Correct.
Here.
So X12 and X13 is there. If she has submitted the original, she can only retain the photocopy, and that pro forma has been filled up. Her photograph is there. If it is there, it is there in the LC.
No, it's not.
It is there in the LC. Page 136. Page 136.
It is not an exhibit.
It is not an exhibit, but it is a document which was taken.
Photographs are there.
Yes. Photograph is there.
Yes, let me place it. This is a format which has been brought on record. पूरा नाम, पिता, जन्मतिथि is blank, शैक्षणिक योग्यता is नहीं, पहचान पत्र, आय, पहचान चिन्ह, हाल के पासपोर्ट के 6 फोटोग्राफ, 1 photograph is there I find, स्थायी पता is there, ये अवार्ड से लाभान्वित होने वाली व्यक्ति के रूप में दावा is not filled up. After paragraph 8, none of the columns have been filled up. And that judgment, which I have given to your Lordship, deals with the format which was prescribed by the Supreme Court. And what else? What are the requirements that are to be filled up? So, this is only giving her name, husband's name, बाएं हथेली में तिल का निशान, present address and permanent address. If she has been working, she must be having her Form B number, CNPF number.
You see, the so-called form, let us assume that you have, but you don't disclose your identity. Without father's name, without basic, that is basic. You don't even disclose that. Have you established your identity? We continue in the second half. खोजिए आइडेंटिटी का एक भी डॉक्यूमेंट खोजिए, तभी हम बोलेंगे कि परवश नहीं है.
Tomorrow the electricity matter is listed.
You have done the needful.
We have done whatever we could do. I am not here tomorrow, so Mr. Vibhasana will make a request for small accommodation on Thursday if possible.
Thursday?
If possible. I am not
Decide you on Thursday. What is the present status?
Present status is we have deposited 23 lakhs for that plantation, which is apart from the brief. So far as status.
You have done the plantation?
No, we had given it to the DFO 23 lakh rupees for 500 saplings. That was what the deal.
क्या लगता है? वो क्या होगा?
वो खरीद लेंगे वो जो हम I have given not only purchase but also for the maintenance. That's nothing to do with the main compensatory efforts.
But
मेरा compensatory efforts.
कौन है? आप स्टेट हैं?
स्टेट तो AG ऑफिस appears.
प्लांटेशन किए कि बस ऐसे ही वो 23 लाख रुपए कहाँ चला गया पता नहीं चला.
बहुत पैसा हम लोग जमा करते हैं. Diversion के
actually your lordship,
it runs into millions.
No, but this is a very serious concern. This plantation is under CSR whatever. But the compensatory afforestation which we do, not only Zendian, what is the outcome no one knows.
जितना प्लांट इन लोगों ने बुक्स में प्लांट किया है उस हिसाब से पूरा झारखंड में एक भी जगह बचना नहीं चाहिए.
नहीं होना चाहिए. That's what the only plantation is happening on records.
Yes.
Records are being planted.
And the amount of money they charge.
सिंडेगा का तो मैं रिपोर्ट आज ही मंगा लूंगी क्योंकि मैंने उनसे कई बार पूछा कि ऐसा कुछ हुआ क्या. बोले हमने तो कुछ नहीं पता. एक डिस्ट्रिक्ट का तो मुझे पता लग जाएगा. You can't get away like that. नहीं तो 23 लाख जितना जमा कराया ना उतना वापस करना पड़ेगा. पीसीबी ऑफिस का आप स्टेट की तरफ से हैं आपको बोल रहे हैं. मेंटेनेंस भी देते हैं आपको पैसा भी देते हैं. और एनवायरनमेंट के चलते आप इनको रोके हुए काम करने से या जो भी whatever you are doing. What is the present status in MOA?
Present status, I just received instructions in the morning that we have been able to acquire 1,900 acres have been transferred. Around 500 acres are pending with the government. So we have almost achieved more than 1:2 of the requirement.
So there is some development from the last day?
Last day. There is substantial development. We have achieved 1:2. And therefore my petition before the government of India to reconsider 1:6 because they are orally informed. If they do 1:2, then we come back. Because it is impossible to get 2,600
acres of land in Jharkhand, not government, non-jungle chhadi in one tranche. And I don't understand if I am polluting in Bokaro, how will the afforestation in Simlega help that locality?
No, no. It is not a matter whether.
No, but whatever it is.
It is the totality.
Totality of.
And environment is absolutely continuous, right? You
Yes.
just can't segregate in blocks.
We will not. That is for the government of India to take a call. We are not even.
अफॉरेस्टेशन के लिए आपके पास जमीन नहीं है देने के लिए, तो जंगल में ही तो उनको बोलिए ना और पौधा लगाने, नहीं लगा सकते.
लैंड देना पड़ेगा मेरे को, तो लैंड दे के नॉन जंगल झाड़ी लैंड दे के उसमें अफॉरेस्टेशन. दैट्स द नॉट इन द एग्जिस्टिंग लैंड. इट्स अबाउट लैंड आल्सो बीइंग कन्वर्टेड इनटू फॉरेस्ट. So therefore I am not here tomorrow. Mr. Bibhasina will be here. If needed, your lordship may kindly accommodate for one day. That is all.
But the affidavit should come maybe on the next.
Yes, no, next.
Your lordship, just a small prayer, your lordship.
Yes.
Serial number 42 is there on board, your lordship. In this direction of the court was to CO to remain present for assisting the court with the entire record of the case. We are praying that we were expecting that it will reach to that.
अभी तक आपको नहीं पता कोर्ट बहुत स्लो चलता है.
So your lordships,
अरे 10 बजे मेंशन करना चाहिए ना. Why have you retained the CO over here? Wasted his time. Who is responsible for this?
we are working for it, your lordship.
काम नहीं है आपके CO को. आप उनको यहाँ बैठा के रख दिए हैं सुबह से.
So, either we have taken out today or a date we will fix after. Because with consent, I have taken consent. Mr. Sani sir, I have taken consent from.
He has got the records.
Yes, sir. He is here in the. He is here. He is with entire record.
From where has he come?
ये पलम.
कहाँ?
चैम्बर चला गया. But he is in the court, your lordship. He is in
बिना
our chamber.
देखे, बिना आइडेंटिटी कार्ड देखे भी अटर्नी.
Your ladies, one matter, your lordship, serial number 20, your lordship. There was direction for personal appearance of the secretary.
Is he
In one
coming?
of the leading matter, we have filed the affidavit, your lordship, pursuant to the amended petition.
That will be taken as affidavit for all the cases.
Yes,
It will be taken up in the second. You be here.